to file an affidavit
Yes, ma'am.
regarding that settlement.
Yes, ma'am.
So that can be treated as an decree.
Yes.
Why you are not able to get the settlement order? I mean,
Yes.
settlement.
Yes.
What
Because
is the difficulty?
difficulty, my lord, if the lordship doesn't set it and quash the lower court order, then will that order, its judgment will remain alive.
No, that's the reason.
Yes.
Had it been so in the normal circumstances,
Yes, ma'am.
we would not have insist to file an affidavit.
Yes.
That's the reason. You know that.
Yes.
You know better.
Yes.
Isn't it?
Yes.
You need another 4 weeks.
Yes, my lord.
On the prayer of Mr. D. Learned Counsel for the appellant.
Applicant.
List this matter after 4 weeks so as to enable him to file affidavit with regard to the settlement by the parties.
Yes.
You just cannot close like this.
Okay.
Appeal cannot be closed like this just because you have settled the matter. Is not it?
My lord, since this is the civil matter,
No, that's why. That's the reason.
Yes, my lord.
Do we need to tell you?
No, my lord.
Do we need to tell you?
No, my lord.
It's a procedure. Am I wrong?
No, my lord.
Anyway.
Much obliged. Yes.
Mayor, Your Honor.
Yes.
Your Honor, I'd like to mention item number 3.
Yes.
I'm appearing on behalf of the Standing Council of Tabatagong. Your Honor. I've taken the consent of the other party. Your Honor, this matter may be adjourned for today and listed after 3 weeks.
3 weeks.
Your Lordship, since this is an order column, as per the office note dated 1/4/24, service report upon R11 is still awaited, Your Lordship.
We'll see. Let us see. Just wait for some time.
Obliged, Your Honor.
In that case, you have to take fresh steps.
We'll wait for the
We'll
service.
see.
report.
We'll see.
Okay.
On last occasion, Your Lordship have ordered for the supply of inquiry report, but we haven't received till now by the registry.
You have not received.
No.
Who was supposed to furnish? Registry.
Yes, Your Lordship.
This year.
You got that inquiry report?
No,
Not yet,
no.
but there is a direction from this court.
Yes, on last occasion, it was sent.
Anyway, then another.
We have the
Three-
copy, you can make a Xerox copy and we can make it available to my sisters, no issue. madam.
Okay.
Or if she wants, she can just have a look to that inquiry report.
No, they wanted to file an affidavit.
Yes, Your Lordship.
Affidavit.
You just furnish the copy of
No
the
issue.
report.
Ultimately,
Will
my
it be all right?
Yes, Your Lordship.
Miss T. Somo. T. Somo.
S. Homo.
S. Somo. S. Somo.
Yes.
You just check it from the learned counsel for the petitioner submits that he is yet to receive the copy of the inquiry report, a judicial inquiry report. Despite direction of this court on 03/02/2024, directing the registry to furnish the same. Mr. Additional Advocate General submits that he will, he can furnish he may be allowed to furnish the copy of the said report to the learned counsel. Accordingly, it is provided that the learned Additional Advocate General shall furnish the copy of the judicial inquiry report. Mr. The learned counsel for the petitioner is is granted 3 weeks time to file affidavit with regard to the judicial inquiry report as prayed for. List after 3 weeks.
We are also ready to file in the.
Mr. M. Kato, learned DHA is also permitted to file affidavit if so advised. This after 3 weeks.
Lordship.
Who
As
is respondent number 11?
respondent number 11, altogether there are 33 private respondents, Your Lordship.
You take process steps in that case.
We have already taken, twice we have already taken, Your Lordship.
Okay. What could be the reason? Respondent number 5 returned back to the Ministry of Recording Service. So can we, when did you take the step?
Your Lordship, as per the order dated 10/11/2022, Lordship,
2023,
22, Your Lordship.
11. Then we'll wait for some time and he is asking for some. Heard MS N. Anju, learned counsel for the appellate. Next para. Office note dated 01/04/2024 reflects that edit card in respect of respondent 5 is received back. However, service report in respect of respondent number is still awaited. This in view of the above. List this matter after 3 weeks.
Obliged.
Standing counsel. The registry is directed to reflect the name of the standing counsel, Mr. T. Tagum, the standing counsel for the Education Department.
Lordship.
My lord, this is a my lord contempt petition, my lord. My lord, this order passed by this this honorable court, my lord, on 6/9/2022, my lord. Whereby, my lord, on the assurance given by this contemners, my lord, the order was passed, my lord, that as directed by the learned single judge, my lord, that the compensation has to be paid within the month of 6 months, my lord. If we count 6 months from 27/6/2022, my lord, then 6 months ends in this December 2022. My lord. Thereafter, my lord, the respondent filed one IA when the contempt petition was moved, my lord. Then, my lord, at that time, sought for a 6 months more time. But this honorable court, my lord, considering their difficulty also, again extended another 3 months. Now, my lord, after giving, my lord, that another, my lord, additional 3 months also, my lord, now, my lord, will see it is almost, my lord, going to be 2 years.
It's okay.
Another
Anybody appearing for respondent number 7?
affidavit I have received, my lord, and from
No
the
idea.
affidavit also, what is in, my lord, only saying, my lord,
You are appearing for 7.
No, I am appearing for the
Who is
6.
for 7?
Newly
Whether the
implemented.
7 has filed an affidavit.
yes, I have
Newly
received.
implemented contempt.
Ah,
I have received, my lord.
Who is this?
7.
Stanley Jammu, Director.
Who is
Civil
appearing?
Aviation.
Filed by Madam Ete.
Huh?
Filed by Madam Ete.
Who is Madam Ete?
Yeah,
G. Ete.
Where she is?
No, I have no information about.
I think it was on her insistence that
Yes.
the respondent 7 has to
Might.
be implemented, so.
And, my lord, from the
See, this is
affidavit.
a
also-
contempt proceedings, sir. Don't take it lightly. We'll take it up tomorrow. Ask her to present.
My lord, in the single
there is a pending writ petition also.
Forget about it.
Regarding the same issue, the land involved is same.
Oh.
And in that writ petition, the petitioner, who is the petitioner in that writ petition, she is claiming that the land belongs to him and she possesses the LPC also. I don't know how this assessment has been in fact made.
No, are you,
Without the knowledge of
have you filed an affidavit?
in that writ petition.
No, here.
Here in fact, no loss.
Then if you are taking that ground, you file your affidavit saying that this order of this court cannot be implemented, is not possible to be implemented.
No, my lord, this is in a contempt jurisdiction.
Yes.
It is the satisfaction of this honorable court between the contemners. Even the counsel for the petitioner also, even the petitioner also has a limited role in this, to be very fair side. And whatever, my lord, the only difficulty in this case is that 31 crore was assessed for disbursement of the compensation to the affected petitioners. Now, there are certain miscommunications within the department. Now, the contender number 6, he is also transferred out. There's ICR, DCICR. Now, the affidavit, it says that the moment state government, particularly the contender number 7, deposit the money, then we will disburse the money. That's it, my lord. There is nothing but that the contender number 7, my lord, has been impleted because there is nobody, the director civil aviation office cannot be remained vacant. The person who is occupying has to initiate the process. Only for that purpose, this contender number 7 was impleted, my lord. I think, brother, I think that is the correct thing.
My lord, I am worried, my lord, going with the manner in which the affidavit has been filed. If they take this kind of plea, my lord, the order is very specific. 6 months, then another extended 3 months, 9 months. Now this is going to be 2 years. My lord, if they keep on going this kind of play, my lord, this will take another 2 years. My lord, only my lord, this is a fit case to draw contempt proceeding, my lord. Because last occasion also, my lord, this court has been quite liberal and has been taken into consideration, my lord. But this is a 2 years, my lord, and the only the lip service they are giving the highest regard for the honorable court. But by conduct, my lord, I don't see it. My lord.
The last occasion also, Lordship, the submission. We'll take it up day after tomorrow, right? You inform Mr. Ms. G. Don't take it lightly.
Yes,
And we preemptively found it that there's a contempt.
That is true.
There is a contempt. And respondent number 7 was has been implemented on her insistence.
Yes.
That unless this man is implemented, unless the fund is released, you cannot pay. Your stand is that you are ready to pay, disperse the money the moment you receive the amount.
Correct.
So there appears to be a fussing the buck to each other. So
Earlier, my lord,
we'll like to hear the respondent number 7.
My lord, the word passing the buck, my lord,
Is
I
the
can
passing
only-
the buck?
my lord, let me
Definitely, I'm
my
sure.
lord,
I'm proud
rightly
about it.
observed, my lord.
My lord, let me in a lighter way, my lord. I can only say there is some miscommunication between the department of
No, it's a fussing the buck. You said you are ready to pay. Your payment is independent, of course, release of the fund by the government.
correct.
So the government has been implemented. The person has been implemented. Who is the director? Filing a casual affidavit. I don't know. We refuse to open it now.
We'll open it day after tomorrow. Inform MSG at it. We may initiate
for what?
day after tomorrow. We'll see.
And my lord, respondent 6 has changed the instance only after chastised by this honorable court because he was sitting over the merit of this order passed by this honorable.
It's okay, it's
Then
okay.
only subsequently, my lord, changed the position.
So you should appreciate the council who has
Yes,
advised.
yes. Before that one, I think.
Appreciate. You should appreciate the council who has advised the contemner, don't sit over as an appellate authority over the judgment of this court.
Day after tomorrow.
That I cannot allow you.
Yes, you should appreciate him.
Yes, my lord, I appreciate. My lord. Deeply applaud.
Grateful.
Uh,
Lord,
Mr.
I am told Mrs. Ete has some personal difficulty of relating to some health or something.
Then we'll call personal appearance of Mr. This Starley Jamo.
Will not kindly.
Would like to see the star.
Well, let us.
Let the matter be fixed.
Somewhere on
taken up on,
8 or 9.
day after tomorrow. Then only we'll
No.
be able to know
No,
the
no,
position of
let us-
Mr.
because
Mr. Ate.
Yeah,
If he,
8 or 9.
8 or 9, let Mrs. Ete come because I will request. my
She's,
brother,
she's,
please accommodate.
she's not coming back day after tomorrow.
Maybe, my lord. Sometimes health issues, it takes
Okay,
time
in that
for
case,
recuperating.
Next is 9th.
No
Nine.
issue, my lord. My associate will be there. only.
That's fine.
No issue.
Heard Mr. Arsenal, learned counsel for the petition.
Yes, I have been informed and also this is out of.
We don't know.
Yes, I am raising this for.
No, it's okay.
But-
It's okay. 9th,
Tell her, it's a contempt
Nine.
proceeding. Tell her, it's a contempt proceedings. Don't take it lightly.
Otherwise, the.
We are all along, we're
Earlier,
little lenient.
was different law. Because so far acquisition is concerned also, that has to be done by the deputy commissioner.
We're not hearing the merit of the matter now. It's a contempt
No, no,
petition.
that only. Because as per direction also,
Yes.
acquisitions and estimation has to be done by the deputy commissioner. And that has to be submitted to civil aviation, who will provide the lawsuit, one lawsuit.
Do whatever you do.
That is done and submitted. Only.
Whatever you want to do, do it. Who is stopping you? Do it. Who is stopping you?
So say earlier the state was there from the civil aviation law. That was not being done by the deputy commissioner.
Sir, we're not hearing the merit of the matter.
There is some, why this lawsuit order is not being complied with. That situation just I'm trying to address.
I understand.
As observed, as
Also,
observed by my lord.
Which for one, respondent number 1?
I don't know.
None appears for respondent number 1, 2, and 3.
I am appearing for respondent number 3 and 5 laws. 3 and 5.
Mr. None appears for respondent number. Alice contemnant number.
7. 6,
Just
I'm
wait,
appearing.
just wait. 1, 2,
Dharmendra, oh, I think it's by.
3, and 7. Mr. D come to for respondent number
3 and 5.
3 and 5. And Mr. Titi Tara for
For
respondent
6.
number 6. List this matter on 09/04/2024.
That's okay.
Much okay.
Number 5.
Your Lordship, the service upon respondent number 2 is still awaited, Your Lordship.
What is to be done?
Your Lordship may fix this matter meanwhile undertaken instruction because the notice was routed through the office of the PP, Your Lordship.
So we'll wait for some time.
Yes,
But the records are there. We can direct it for preparation of paper. book.
yes, yes,
Okay.
yes.
Heard MS J. Doji, learning.
LSE.
State counsel
Yes,
for the appellant
yes, FN.
and also this. TG learning additional people for the state. Office note dated 01/04 reflects that service of notice in respect of respondent to state. Awarded list of. It is noticed that LCR TCR has been received. List of. The registry is directed to prepare the paper book. List after 3 weeks.
Deeply obliged.
Number 6.
Lordship, extra copies has not been served to us, Lordship.
Yes.
Extra copies.
Why,
I,
why do you need an extra copy for IA? This continuation of delay
yes, Your Lordship.
of what? Where there is a 207.
207 days.
There's nothing in the body of the petition, and in prayer procedure it says 186 days. May not be interested. We'll conduct the delay and dismiss the writ petition because there's no merit writ appeal. There's no merit in the writ appeal. They are claiming that they should be regularized from the date of the
Yes.
completion of the length of service.
Lordship.
That cannot be. It's not a law. Who is appearing?
You, Decca, is the counselor. Lordship. हो जाएंगे.
There should be completion of length of service. Non-affairs on call. We'll give another chance. Otherwise, we thought of allow the condemnation petition and then dismiss the writ appeal. Non-affairs on call. The non-affairs for the applicant, public appellant on call. MS Arbasar, London State Council is present. List after 6 weeks. In view of the discussions made herein above, and by considered view, no relief can be granted to the petitioner as per for this stage. However, it is provided that in the event the appointment letter of the respondent for is proved to be forged one and found not genuine before the appropriate forum, the petitioner is liberty to approach any appropriate forum for redressal of his grievance at any stage. Writ petition stands disposed of. Appeal dismissed.
May I please, my lord?
Yes.
My lord, I have to mention that, my lord, it's an urgent tender matter, my lord. May I humbly pray, my lord,
Tomorrow.
today, my lord, my lord.
Tomorrow.
It's a very,
What urgent?
if time permits, my lord. Today, my lord.
Let us see.
Obliged, my lord.
Mayor, my lord. This writ petition is.
Not maintainable.
Yes, my lord, it should be listed before the division bench.
Yes.
Yes, my lord, they have challenged the virus of the act.
Let's this matter before
Tomorrow, my lord.
the
Well,
bench.
38 and 41, man. 38 and 41. 41, yes. Go on.
38 and 41
41.
before division bench. Huh?
Obliged.
I think over 39.
Meet me, Lord.
Yes.
My lord, in this petition, my lord, we are basically aggrieved by the manner scheme has been implemented. That is a vibrant vigilance program under the PMGSY scheme.
Yes.
My lord, to be at the outset, my lord, I would like to clarify that we are not opposing to the scheme with the NIT, my lord. But the manner they have done it, my lord, we are aggrieved by that. My lord, the scheme, first your lordship will take up the the communication of the secretary of the RWD, my lord, at
Yes.
page 24.
Hmm.
I'll take your lordship to the last paragraph, my lord, of page 24. But the process of land donation drive require organizing a transact walk by administration, association, departmental engineers together with the Panchayat Pradhan, local revenue, land records, and forest officials. On completion of the event, a proceeding of the meeting shall be drawn and duly signed by all the stakeholders. Allow to mark this. Open and transparent communication between the community and the local authorities build trust. Therefore, for ensure of successful drive, it is essential that all stakeholders are well informed about the project objectives, benefits, and potential impacts of the livelihood. Now, my lord will kindly turn to page 26, my lord, the approval of the projects, my lord. Page 26, my lord, 2 Roman 1, my lord, to find. It mandates that the latest SOP related PMGSY issued by the MORD shall be followed while implementing the road project, including any amendments in the SOP issued from time to time. Now, my lord will find the SOP starts from page 28, my lord, the guidelines. The relevant would be page 40. My lord finds page 40.
Yes.
6.12, my lord.
1, 2.
6.12.
Hmm.
It will be the responsibility of the state government district panchayat to ensure that the lands are available for taking up the proposed road works. The certificate that the land is available must accompany the proposal for each work. It must be noted that the PMGSY does not provide fund for land acquisition. This does not, however, mean that the acquisition cannot be done by the state government at its own cost. The state government may also lay down the guidelines for voluntary donation, exchange, or other mechanism to ensure the availability of land. The process of making land available for the road work should subserve the common good and also be just and equitable. The details of the land made available should be reflected in the local land records to avoid dispute. 6.13, it may be that the road works are sometimes held up because at the time of preparation of the DPR, actual availability of land was not investigated, or because the local panchayat was not taken into confidence about the proposed alignment and dispute subsequently arose. As a part of the PMJ process, all states shall include, my lord will kindly note this, all states shall include a simple non-formal transact walk to be organized by the assistant engineer at the time of preparation of the DPR.
What
The
do you mean by this transact work?
My lord, this means, my lord, when the identification will be done where the road will run through, the authorities will take into confidence the local authorities, the panchayat, and the persons who will be affected. And after this is done, they will sign a minutes. Everybody will sign a minutes, accepting that this road will run from this land. I'll start from again. The Panchayat Pradhan, local Patwari, JE, women, PRI members, and representative of the women self-help would participate in the transact work. Now, my lord will find clause 8 provides the measures that has to be taken while preparing the my lord, the DPR. Clause 8 starts from page 42. I'll take your lordship to page 43, 8.4, my lord.
It's okay, we'll issue notice. What's there?
But at this stage, yes, lordship will issue notice. My lord, what we are praying for is, my lord, similar petitions were filed before this honorable court. This honorable court did not stall the process. It allowed the government to go ahead with the process, but by following the guidelines that is provided, my lord. Your lordship will find that order, page 82, my lord. Page 82. The operative portion, my lord, will find it page 84.
Hmm. It's indirectly,
No, this, my lord, it has been clarified that
your
the-
claim is that they have not
followed the
followed the
guidelines.
SOP.
Followed the guidelines.
If it is to be the
In fact, your lordship,
executed as after following all these things, it's indirectly there's a stay of the.
no, my lord, the lordship will kindly take up page 85 for a moment. The authorities has already withheld the tendering process, taking note of that this process was not followed. Page 85 is the letter of the chief engineer. An instruction has been issued to the page 85, my lord will finds. It's an instruction to the superintending engineer and the executive engineer, my lord will find Haulian. And that is the authority who has issued the NIT in our case, my lord. And your lordship will find the last line. You are requested to withhold the tendering process till the process of acquisition is finalized.
If the guidelines and the scheme doesn't provide a compensation,
My lord.
how the state government will
State-
be forced to?
State has possibly has adopted a policy, and therefore this chief engineer has.
My lord, the present case, nothing will be done before 19. So this is nothing, all political litigation. I am told that some candidates said tender should be plot, some said it should not be plot before election. This is nothing, all after election, everything will be gone.
So we'll wait
Just give
after the election.
My lord,
You move this petition after the election.
Yes.
my lord, in fact, my lord, in my petition as well as the
Anyway,
representation, we
wrongly or
have
rightly,
categorically said,
the
my lord, we are not
coordinate
objecting
bench
to it.
has issued a notice.
Even secretary has also given notice to the executing authority. They has to follow the guidelines.
Yes.
The guideline has to follow.
My lord simply observe that, and my lord will tag with this writ petition, my lord. There's no way of not adhering to the guidelines that is issued by the under this scheme, my lord. That
Heard Mr. D. Kaushik, counsel for the petitioners. You are the landowners.
landowners. My lord.
The petitioners claiming to be the landowners
My lord.
of 10 villages of Hauliang block under Hawaii headquartered in the district of Anjao. Stated to be aggrieved by the action of the respondent authorities for implementation of Vibrant Village program under PMJSY scheme of the Government of India. As the same is being initiated without following the relevant PMJS program guidelines as well as the SOP thereto. Issue notice returnable by 4 weeks. Mr. Who else are appearing?
I am appearing for 3.
Just wait. Let us see. Union of India,
So,
Union of India. No, and copy.
he was here. Have you served the copy?
Yes, no? Copy. Sir.
Mr. M. Kato, learned DSJ for respondent number 1 and 2. UFO,
4 and 5.
P. Sangeeta, learned State Council for respondent number 4 and 5. G. Tarak for learned Standing Council for
3,
RWD for respondent number 3,
3, 6,
6, 7,
9, 10,
There-
not 7, 9 and 10.
3, 6,
3, 6, 9 and 10.
9 and 10. List of since the learned council for the respondent number 1, 2, 3, 4, 5, 6, 9 and 10 enters appearance accepted notice on behalf of the respondent. No formal notice in the basis of our exit copies be furnished to the learned council for the petition. Respondents, learned council for the respondents. Petitioners to take a step for service of notice upon respondent number 7 and 8.
7 and 8 also, I think, learned CGC.
I think technical because
Mr. Kato can take notice of.
no, this is you'll have to take. I think
I'll take
7 and 8. huh?
I'll take steps.
7 and 8.
What's register posted?
Where is that was with 8 within 3 days from today.
Extra copy.
Yes, I've said. If furnish exit.
I'll
Page that is issued the letter of
the chief engineer, my lord,
chief engineer.
page 85.
So in view of this, no order is required.
My lord will
Yes.
just clarify that the guidelines to be followed whenever this tender process is till at this time, my lord, it has already been withheld, my lord.
It is next para. It is provided that if the state if the respondent authorities is decided to proceed with the implementation of the vibrant village program in question, the relevant scheme, relevant guidelines, the PMJSY guidelines and the SOP there to be followed.
Must.
Mr. That's all. List after 4 weeks, along with the writ petition number
WPC number, my lord, 99
99
oblique
20,
24.
20.
99 oblique 24. Highly blessed, grateful.
Yes, sir.
My lord, this petition is filed arising out of the infin order passed by the Secretary Land Management.
Where it is?
My lord, it is page number 89.
89.
89, page number 89. Whereby my LPG petition number 1 LPG has been cancelled. Page number 89, annexure 10.
Yes.
And then after, why this, my LPC has been cancelled, my lord? This order was passed based on the order passed by the judicial magistrate first class. There is an order passed by the judicial magistrate in domestic violence case. And wherein it is directed that the land should not be alienated. So this order was passed based on that order, my lord. May I take to page number 58? Annexure 3, my lord.
What's wrong in there?
My lord, in DV domestic violence case, otherwise first against petitioner number 2, not to alienate the plot of land.
Yes. You have
And-
obtained an LPC and then alienated it.
I have often LPC and I alienated.
Yes.
Then, my lord, I have committed offense. So, for example, I am admitted that I have committed offense by alienating the land, violating the breach of protection order passed by the judicial magistrate first class. Then if I have committed wrong, a breach of protection order,
It is to by the
There-
action has to be by the appropriate authority.
yes,
Court.
section 31 of Domestic Violence Act had to be acted upon me.
So will
Not-
that will direct the court to take action against you.
So, my lord, so that the respondent, private respondent number 4, it ought to file complaint against the petition number 2 under section 31. So here the order is passed by the judicial magistrate first class, but not by the deputy commissioner, not by any revenue authority. So since order is passed by the judicial magistrate first class, but that order has been taken advantage by the respondent number 4 by filing a complaint before the deputy commissioner for cancellation of LPC. And this, due to some administrative reason, deputy commissioner has not disposed the application. Then again, the respondent number 4 filed a writ petition before this honorable court, seeking direction to direct the deputy commissioner to dispose the complaint. So accordingly, this honorable court has passed an order directing the deputy commissioner to dispose the complaint within a period of 1 month. So accordingly, the deputy commissioner passed an order after hearing both the parties, thereby rejected the complaint lodged by the this respondent number 4 on the ground that since the order passed by the judicial magistrate is not within the purview of deputy commissioner, not authority to interfere the order passed by the judicial magistrate first class in domestic violence case. So the deputy commissioner is not within the purview of the Domestic Violence Act. So it is either territorial jurisdiction, encroachment of territorial jurisdiction of the judicial magistrate first class. Therefore, the deputy commissioner has rejected the complaint of the respondent number 4, my lord, because there is no any jurisdiction. So complaint had to avail section 31 before the order, before the judicial magistrate first class, who had passed the order.
What is your submission? That the Secretary Land Management doesn't have that authority
Yes, my
to
lord.
cancel the LPC?
Yes, my lord.
Are you sure?
Yes, my lord.
You have
So this is not arising, the writ petition is arising out of the complaint lodged by the respondent 4. Again, that complaint is arising out of the order passed by the judicial magistrate first class, my lord.
appeal lies.
My lord, yes,
Appeal
appeal was,
lies before the Secretary.
yes, the respondent number 4 has filed appeal before the secretary against the order
Appeal
passed
lies.
by the,
Appeal lies.
no, appeal has been disposed.
No, appeal lies.
Before
Is there
the-
any provision for appeal before the Deputy Commissioner?
No, my lord.
Then,
In the Domestic Violence Act,
no,
There is-
not domestic violence. The cancellation of the LPC.
yes, my lord, section 83 of Arunachal Pradesh Land Record Revenue Act 2000, section 83. Appeal can be filed before the Secretary Land Management. And accordingly, this infin otherwise passed based on that appeal, my lord.
So according to you, the Secretary Land Management who has passed this impugn order has no jurisdiction.
Jurisdiction in accordance to the order passed by the judicial magistrate first class. This is my submission, my lord.
No, you have said page 90. Your submission.
Page 90, my lord.
Yes, paragraph 3. Page 90.
Yes, my lord.
Read it.
Para 3, my lord. Mr. N. Taladed counsel appearing for the respondent number 2 and 3 submit that the present appeal is not maintainable in law in age much age the Office of the Secretary, Land Management Department, Itanor, has no jurisdiction to decide the title of the subject land, and the order dated 16/1/2024 passed by the learned Deputy Commissioner is not to be interfered. So I have submitted before this appellant authority on the basis of the order passed by the judicial magistrate. So as for the order passed by the judicial magistrate first class, DC has no any authority.
Otherwise, it's appellable order.
In the other case, in the revenue authority can interfere on the other case, but not in the
LPC
division.
cancellation is a revenue matter.
This is arising out of the division, the domestic violence case, my lord.
No, forget about suppose the land has been cancelled, the LPC has been issued.
Yes, my lord.
There has not been, there was a complaint before the DC to cancel it. That complaint has been rejected.
Yes.
It is a matter of LPC only.
Matter of
So
LPC.
is it a revenue matter?
It is revenue matter, my lord.
So it's
Again, LPC is again arising out of the order passed by the judicial magistrate first class, my lord. Judicial magistrate first class has passed an order directing the respondent number 2 not to alienate the plot of land till the pendency of the domestic violence case.
So you have obtained the LPC on the basis of the order of the magistrate?
No, before passing of this order, I have obtained LPC in 2009, my lord. And order was passed only in 2015, my lord.
Yes.
Order was passed in 2015. That is page number 58, my lord.
It's okay, that I've understood. What I'm on is that whether the rejection or cancellation of by the Deputy Commissioner of LPC is an appellable order or not under the law.
No, my lord, what happened? Now,
Forget, for a time being, you forget that domestic violence.
my lord, in the complaint, this order of the judicial first class has been annexed in that order, in that complaint, lodged by the respondent number 4. And if that order is not been included part of the complaint in that complaint.
She may be correct because having an LPC is one thing and alienating it, being a LPC holder or something like that, then is not permitted by the restrained by the magistrate in the Domestic Violence Act. So you are not having only the LPC. After having an LPC, you have mortgaged it to the bank.
Yes, my lord.
It's amounts to alienation.
So I have mortgaged the LPC, and after that I have also transferred the ownership of my land by virtue of gifted. And the respondent number
Okay, forget that now. Now you just tell us the challenge in this writ petition is the order 12/3/2024 by the secretary as an appellate authority. What's wrong in this?
My lord, this order passed by the judicial first class was the part of the complaint of which was lodged before the Deputy Commissioner.
What's wrong in this order?
No, my lord. If that order is not been the part of the complaint, then DC can interfere. And if DC has rejected the complaint, then this is the affidavit.
DC is in your favor.
Yes, my lord.
Now you talk about this, you are aggrieved by the order of the appellate authority.
Yes, my lord.
Which you have admitted that the appeal lies. As an appellate authority, what's wrong in this order?
My lord, here,
Point out.
as per the order, the order itself reflects the order passed by the judicial magistrate first class. In the last page number 89, in the last para.
Yes.
Yes, but as per this order, even in the page number 90, order of the judicial magistrate first class has been reflected. The respondent number 1, the secretary land management, is not a judicial authority to interfere the order passed by the judicial magistrate first class. And if this order passed by the judicial magistrate first class is not a part of the document, then the secretary land management can interfere on the subject matter of LPC, my lord. But here, the appellate authority has reflected the order passed by the judicial magistrate first class. He is not the authority to interfere.
After the order of the magistrate, sorry, the LPC was issued by the
If
deputy
the-
commissioner.
At that moment of time, LPC was not issued, order was passed only in 2015.
15.
Yes, on
That LPC was passed, issued,
LPC was issued in 2009, my
and the gift deed was on 2016.
16, my lord.
Gift deed,
Was
not the
executed,
LPC, gift deed would have been cancelled.
it was in 2016, my lord.
Yes. After the order of the magistrate.
After, before order was passed.
LPC was granted in 2009,
9,
and you have made the gift deed was made on 7/10/2016
yes,
after the order of the
after
magistrate.
the order.
So this gift deed could have been cancelled, not the LPC. That is what you are trying to say.
No, but gifted, this respondent number has to challenge the gifted. Has to challenge the gifted. Not to complain for cancellation of the LPC. First of all, gifted has to be challenged first.
He is very wise. He wants to cut from the root, not
So-
the branch.
Then only come to the cancellation of LPC.
If LPC goes, everything goes.
Now, my lord, again,
So he's wise.
the
Or he or
respondent
she
number
is
4
wise.
is, had got divorce also.
Yes, what do you say? He is saying that though you have the authority, but then you could not have cancelled the LPC because if you cannot cancel the LPC on the basis of the order passed by magistrate. The recourse is to approach the magistrate, not by the DC and the authority. I mean the secretary land. What do you say?
Lordship, in fact, the Court of Judicial Magistrate or Civil Judge Senior Division do not have the jurisdiction to cancel any LPC issued by the competent authority. It can only pass direction. It can only give direction to the authority,
Sir,
competent
don't-
authority.
Don't confuse me again.
Yes.
My lord, I think we are very confused. LPCs are issued by a guideline of 1988. And then this Land Record Settlement Act is totally different.
That's why I asked him whether it's LPC is LPC issue is a revenue matter. He said it's a revenue matter.
No, my lord.
He says appeal lies, but then the manner, the ground which has been cancelled, the ground on which basis the LPC has been cancelled, the basis which has been is the magistrate order, which he could not have done it.
Yeah, that will
On
come
other
later.
ground, he said.
That will come later on, my lord. First of all, LPC is issued under a guidelines. And it is the deputy commissioner who has to issue the LPCs. Above 50 acres, that the approval of the government is required. If there is anything, any complaint regarding the issue of LPC, in that guideline, there is no provision that it should, there is an
there's a
appeal.
Rule made under the Land Settlement Act 2012, there's a rule.
Yes.
Where provides the provision for LPC.
That is, my lord, that's, that
By-
is when the cadastral survey is made, when the apportions are done in any dispute with regard to that. Now, these initial LPCs are not issued under the Land Record Settlement Act also.
Therefore, no appeal lies.
Therefore, no appeal lies. Still, the process of
He's saying otherwise.
that's
Other way
what
around. He's saying
It is
he's submitting
quite
that
mixed.
appeal lies, but then the manner or the basis which the LPC has been cancelled.
I
is
think
not
it's
proper.
the wrong presumption that
Yes, my lord.
So we'll clarify this.
Yes, my lord. As for the LPC is not disputed, but the way of order passed by the respondent number 1, the secretary land management, is illegal. Why? Order of the judicial magistrate first class is passed in the domestic violence case, not in the civil case again. So there is a jurisdictional separation.
That is your interpretation of the impugn order.
Yes, my lord. So order itself reflect the order passed by the judicial magistrate first class. If it is of the cancellation of land, order need not to be reflect the order passed by the judicial magistrate first class.
No,
And order is
that's
very
why-
much clear.
That's why I'm saying, number one, if you are saying that the appeal lies.
No, in LPC, if the LPC is cancelled, then appeal lies. That is different.
London Additional Advocacy General is saying differently. He's saying
It is
contrary to
different.
what
It
you
is-
are submitting. He
My lord,
said
it is a different issue.
it's an LPC matter which is not includes the revenue matter, which cannot be termed as a revenue matter. Therefore, appeal doesn't lie.
My lord, here the order passed by the respondent.
Anyway, if you are saying that the appeal lies, it's okay. We'll examine it. We'll issue notice. No stay.
My lord, the particular operation, order passed by the judicial magistrate first class, can the secretary lead management, is there any provision, is there any jurisdiction to interfere?
No, he is not interpreting. He said, since there is an order of the magistrate, you could not have alienated the property. But one thing is that he could have interfered with the gift deed, not the LPC.
My lord, therefore, section 31, the respondent had to oath to file complaint against the petition number 1.
Anyway, it's of no use.
So my lord,
We'll give an opportunity to the respondents. And
Ma-
Mr.
my lord,
Tajay, huh?
my lord, the DB case is pending.
And Tajay,
It's still
Nirab
pending.
Tajay, Learned Counsel, huh?
The domestic violence case
Why not
is still
concern?
pending.
It's okay. But then that order still remains.
Order is still in force.
Restraining as order still remains.
Yes.
And Tajay, Learned Counsel for the petitioners. And also heard Mr. They come to for respondent number 1 and Learned Standing Counsel for respondent 1 and 2. Deputy Commissioner,
yes, my lord.
Mr. N. Ratan for respondent number. Learned Additional Advocate General for respondent number 3. Page, what is the impugn order? Page
Page, my lord, 89.
challenge in this petition is the order dated. Order number, page 89. Secretary so and so dated. (12/3/2024) passed by the Secretary within bracket LM Government of Arunachal Pradesh. Whereby, comma, on appeal, comma, the LPC issued in favor of Srimati Lika Nap. Respondent, petition number 2.
Yes, madam.
Petition number 2 has been, comma, is cancelled. Mr. N. Tajay, Learned Counsel for the petitioner, contains that the the basis on which the LPC of petition number 2 has been cancelled.
One,
Respondent number 1
one, yes.
has been cancelled. Is it Sri Likanap? Srimati Likanap?
Yes,
Petition
that and
number 1.
response number 3 in before the affiliate authority.
It's okay.
Now in petition number 1.
Srimati Likanap, petition number 1 is the order of the magistrate passed in judicial magistrate first class passed in which order that is 10/6/2015 passed by the magistrate judicial magistrate first class UPA
Yes,
in
ma'am.
domestic DB case number
06/2015.
06/2015 list of issue notice returnable by 3 weeks since the learned counsel for respondent number 1, 2, 3 are duly represented, no permanent notice need be served by extra copies be furnished to ensure. The learned counsel petitioner to take steps for service of notice about respondent number 4.
My lord, if it can be observed, the larger question to be decided whether LPC is issued under any provisions of law and whether the Land Revenue Settlement Act will be applicable in this case. That issue may be to be decided.
He's not raising anything.
No,
Otherwise,
we'll
what
decide
does-
those in appropriate proceedings. He's not raising, he said appeal lies.
No,
That- because there are so many
LPC
cases.
My lord, LPC is not in the disputed position. The way here in
In
challenge
the
is that
interim, considering that the appellate authority has cancelled the LPC of the petition number 1 on the basis of the order dated 10/06/2015 passed by the JMFC, UPA in DB domestic violence case number
06/2015.
which this court prime facie finds it not could not have been a basis for cancelling the LPC, the impugned order dated 12/3/2024 shall remain suspended till returnable date, till next returnable date. It is made clear that the no, Christopher. On the submission of London Additional Advocate General of the state, the larger issue as to whether the issue of LPC, what is that?
LPC, the issue of LPC under a notification will be covered by the Arunachal Pradesh Land Record and Settlement Act.
The larger issue as to whether the issuance of LPC falls under the purview of Arunachal Pradesh Land Settlement Records 2002 is kept open for deliberation.
My lord, then status quo may be brought. I have an interim here, my lord, here.
I have stayed the impugned
my lord.
order till returnable date.
Like my lord.
In that case, we'll say not status quo agent instead of suspending.
No, my lord, I have an
Just
interim chair
status
here, my
quo.
lord.
I want to give what you want.
Sorry, my lord.
So status quo agent today shall be maintained. I suspended it. You said you
my lord,
because I don't want
sorry, my lord.
you to make unhappy.
No, my lord. I have not.
As you wish, I have granted. Thank you.
My lord.
Mayor, please, boss. My lord,
What's the ground? There's nothing.
my lord, there is office memorandum. issued
No,
by the
once
government.
it is withdrawn, it's up to them. It can be, it goes to the next L2. It's okay. We'll issue notice, nothing.
Now kindly see page 38, man.
38.
Yes, ma'am. This is the office memorandum ma'am, issued by the government of India, man.
We'll
Minister of
examine
Finance.
it.
Yes, ma'am. Page 38,
38,
ma'am.
we'll examine it. No stay.
My lord, kindly see, my lord.
38.
38, my lord.
Yes.
Existing para and amended para, my lord.
It's all our guidelines. It's okay.
If the bidder whose bid has been found to be a lowest evaluated bid withdraws or whose bid has been accepted, fails to withdraws or whose bid has been accepted, fails to sign the procurement contract as may be, or fails to provide the security as required for the performance of contract, or otherwise withdraws from the procurement process, the procuring entity shall retender the case.
Procurement entity shall cancel the procurement process where it is retender.
Retender. It should be retender, ma'am.
Where it is.
It should be after award, ma'am.
You read it again.
Yes, madam.
Page 38.
Page
If
38,
the
my lord.
bidder who is found to be
Amended para,
amended
ma'am.
para.
Yes,
Ah,
ma'am.
yes.
If the bidder whose
Whose
bid
bid
has
has
been
been
found to be the lowest evaluated bid withdraws or whose bid has been accepted, fails to sign the procurement of contract as may be required, or fails to provide the security as may be required for the performance of contract, or otherwise withdraws from the procurement process, the procuring entity shall retender the case.
It is
First,
on two
madam, lowest bidder,
contingencies.
not lowest bidder, first, madam,
Two
first.
contingencies.
Yes, ma'am.
One is if you fail to
First, my lowest evaluated bid
fails
withdraws.
to sign the procurement contract as may be, or fails to provide the security. Two contingencies.
Yes, my lord.
Not,
First,
not otherwise.
kindly see, my lord. If the
Well,
bidder,
you show us after the acceptance whether he has failed to sign the contract
my lord, kindly see the
or
first
fails
line.
to sign
First
the
line.
contract.
First line. Kindly,
Yes.
sir. If the bidder whose bid has been found to be lowest evaluated bid withdraws.
We'll examine it. But prima
Well,
facie, it's only two contingencies. Show us that the respondent has failed to sign the contract. Number two, if he has failed to what is this? Provide the
My lord,
security.
in my humble servant,
Two
there is two contingency, madam.
Yes.
First contingency, if the lowest bid withdraws his bid.
No,
first.
that is not that.
Second is that his bid, contract has been awarded, but he fails to sign the contract. This is two contingencies, as per my humble understanding.
It is.
What is reads, my lord.
Withdrawn or whose bid has been accepted. That was accepted.
My lord, there are two bids, my lord, L1 and L2. L2 has been withdrawn his bid, my lord. Now L2 has been, my lord, given the award, my lord. But as per this OM, my lord, it has to be retendered, my lord. L2 cannot be given the award, my lord. My lord, subsequent page is also there, my lord. It's my manual for my procurement of goods 2022, my lord. Clause 7.5.11, small f, my lord. Same is there, same
No, no.
provision is there. Well, kindly
This is
appreciate
part
my-
of what?
This is part of, my lord, manuals for procurement of goods 2022.
It's applicable in the present case.
Yes, ma'am, this is applicable, ma'am. Well, in my humble understanding, well, there is two contingencies. First is if the lowest bidder withdraws, and second is, well, the person, the firm who has been awarded the contract refuses to or fails to, my lord, sign the contract. These are two contingencies in my humble understanding, my lord.
The contingencies are into this, fails to sign the procurement contract and then fails to provide the security. That's the contingencies.
My lord. First, my lord,
First withdraws
first bid, my lord.
or whose
Yes.
bid has been accepted.
Second is accepted, my lord.
Not
And-
accepted, it says or. It's
Or
not on. And
Accepted, and he fails to, my lord.
no, no.
Highly
See,
appreciate, my lord.
withdraws or bid has been accepted,
Yes, my lord.
right? Fails to sign the procurement contract?
My lord, in first condition, my lord, there is no necessity of my lord signing the
It's
contract.
only after the acceptance.
Yes. Second contingency, this my lord, signing of this contract is necessary and my lord's deposit of security is necessary, in my humble understanding. In second contingency. my lord.
Yes.
My lord, first of all, this is a office memorandum issued by the finance department, my lord. It's just a mere guidelines, my lord. It will not bind the terms and conditions of the NIT. Now, secondly, my what my brother is harping on that amendment para. My lord, you lordship rightly said there are two conditions.
No, I have changed my mind.
My lord, lordship may kindly read. It
After
cannot be-
reading again and again, I have
My
changed
lord,
my mind.
It cannot be segregated. It has to read harmoniously, my lord. My lord, he
Then
said,
because the word uses the or, not the and.
yes, my lord,
One
withdraws or
whose
bid
bid
has been accepted. Withdraws. That means, my lord, after completion of the process, my lord, technical financial bid declaration that you have been selected. And here is that process was not completed. My lord, two firms they qualified. Then before declaration of the bid process, my lord, then one person withdrew, my lord. Then second L2 was awarded, my lord. So this will not apply, my lord. That's my submission. And this yes, your lordship may issue notice, my lord, no problem.
Not from my side, my lord, this is not permissible, my lord. Is for this OM as well as my lord, this procurement of manual for procurement of goods, my lord.
Your technical bid has been rejected.
My lord, in technical, my lord,
Unsuccessful bidder, my lord, in short, you can say.
not unsuccessful, my lord. In technical, I am successful, but because of some shortcoming in my sample, my lord,
That's
therefore
right.
my bid was not taken for financial operating. my lord. That is. But I have
rejected.
that can be.
That's what I said.
But my lord, I have right. Because my lord, the word retender is given in this order.
These are the part of the documents. This
Yes,
no, my lord.
office,
This
this
cannot be.
office memorandum applies.
This cannot be, my
Yes,
lord.
ma'am. Of course,
Then
my lord,
what,
it's
what about Annexure 13, page 39
page 39,
is a part of bid document,
this is not a part of bid document, my lord, but this is part of this manual, man.
manual.
Yes, ma'am.
Anyway, keep it.
Keep it.
Learned Additional Advocate General, please read it again, page 838. Amended para.
Page 38,
Let
my
us
lord.
read it together again.
My lord, let me read first, my lord.
It depends on the interpretation of this clause
Yes, my lord.
for passing an interim order.
May I read, my lord?
Yes.
If the bidder whose bid has been found to be the lowest evaluated bid withdraws,
Withdraws, huh?
number one, or whose bid has been accepted, then your lordship may kind of withdraws and acceptance. When it can be
No.
done, my lord? After the tender process is completed, my lord. Suppose, my lord, I become the L1. There is LY is given to me, my lord. Even then, my lord, I withdraw. That's saying that I'll not accept. I withdraw my bid documents, my lord. And the another is accepted. After accepting the letter be accepted given by the authority, then I say, no, I'll not sign so and so. These are the two conditions, my lord. This indicates my lord, process was completed. After completion of the process, then if someone withdraws or even after acceptance, my lord, fails to sign the whatever document, my lord, in that case, my lord, because at that time there will be no second what you call L2, my lord, because process was completed. And here is the case, process has not completed, my lord. There were L1 and L2. But in the midway, my L1 you withdraws, my lord. The left out is L2, my lord.
Before completion.
My lord?
Before completion.
Before completion. So it was
After the
awarded.
financial bill.
Yes.
After financial bid, he has withdrawn, ma'am. Kindly, my lord, may I read again, ma'am? If the bidder whose bid has been found to be the lowest evaluated bids withdraws, ma'am. This is first, ma'am, contingency. Second, thereafter, or whose bid has been accepted, comma, ma'am, kindly appreciate, comma is there, ma'am, comma, fails to sign procurement contract as may be required, or fails to provide the security as may be required for performance of contract, or otherwise withdraws from the procurement process, the procuring entity shall retender. My lord, in my humble submission, my lord, it is clear, my lord.
Then, well, another question will arise, my lord, whether is all these terms and conditions was a part of it or not, my lord.
Is there any the from where we can find out that the bid has been withdrawn?
Yes, my lord. Yes, my lord.
L1 has withdrawn the bid.
Yes, my lord.
Okay, page 29.
My lord, page 28 onward, my lord. Page 28. Page 28, my lord. This is
29.
29 is the relevant, my lord. 29, page 29, my lord. Annexure 8 series. Sub to the chairperson tender selection committee, subject withdrawal of bid. Madam, with due respect and humble submission and inviting reference to e-tender notice number such and such, dated such and such, and referring opening of financial bid on such and such, it known to that our firm is L1 bidder for supply of school kit to your esteemed department.
I think it's a matter of withdrawal. You should retender it. Anyway, we'll see.
But it said, Mala, before Mala process is completed,
Hmm.
had it been Mala after process is completed, then in that case, yes, my lord.
No, it's completed after the opening of the financial bid,
Financial bid.
and he found to be that L1.
But your lordship know
And
there
he
are-
withdraws, then you have awarded the L2.
but your lordship knows, Mala, even the L1 is not necessary that award should be given to him.
No, it's correct.
That is here, that is here.
There are so many
But
other parameters.
No,
to
you
look into.
are disputing this office memorandum 21 April 2020.
My lord, I am
Whether it's
disputing, Mala,
applicable or-
had it been a part of the SBD.
But then this page 39,
My lord,
almost the same clause, the procurement entity may cancel the process so and so.
page 39, my lord, yes.
Yes.
Well, that's why I said, my lord, after financial bid, this firm, he withdraws, my lord. The withdrawal of the bids, my
Just
lord.
wait. Why you are relying this page 39?
Page 39, my lord. My lord, actually, my lord, this OM, my lord, he is incorporated in this page 39, my lord.
Huh?
This
Where
OM,
where it is?
my lord, kindly see, my lord, 78 down below. Notification, my lord, down below 78, my lord. Footnote, my lord.
Huh?
Footnote, my lord. Page 40, my lord. Page 40 footnote. Notified by the OM number such and such issued by the Department of Expenditure dated 21/4/2022.
Where it is?
My lord, up, my lord. Small-
Yes, I have seen it. Notified the same the office memorandum,
Yes,
21/4/2022.
My lord,
But
this-
then,
My lord, this provision has been, my lord, incorporated, my lord.
78.
Yes, my lord, 78.
Where is 78? Where it is incorporated?
My lord, kindly see F, my lord, page 40, upper part, my lord, F. Last, my lord, retender the case, then, my lord, there is 78.
Retender the case. Huh?
There is 78, my lord, numerical 78, and footnote 78, my lord.
Yes, footnote I've seen, but
Yes,
where it is? Where it is incorporated? Where is 78?
Well, But phase 40, yes, but phase 40, my
That
lord.
has been found to be. Yes. It is part of the bid document,
My lord,
standard bidding document,
SBD, my lord.
SBD.
This
Is
one,
it
my
a part of the
Page
SBD?
page 39, my lord.
Page 39, 40? Yes,
My lord, they are not a part of bid document.
Huh?
They are not part of bid document.
it's not a part of the,
Bid document. But my lord, likewise, my lord, this has been followed, my lord. For procurement of goods, this manual has been followed, my lord. There is no dispute on that, my lord.
he is disputing it. This page 39, 38 has
Yes,
been
ma'am.
incorporated in the manual. There is page 40, F, first para, top. Page 40.
Yes, my lord, page 40, F.
Hmm.
My
So
lord,
according to him,
my lord,
this 38 has been incorporated in the manual which is being followed in this matter.
Yes, ma'am.
then
That's on-
definitely this will be, my lord, part of the SBD, my lord. Then,
So I'm of the prima facie
Yes.
view that if
If my friend
L1,
can-
L1 is withdraws, you have
But-
to retender.
man, if my learned friend can, my lord, certify your lordship, this is part of the SBD, then my lord matters.
Let
This is a, my lord,
Notice,
yes, ma'am.
well,
in the meantime,
yes. I'll take the
if,
instruction.
if
we can.
no final order is passed, I mean, award is, if no final order is passed pursuant to the tender,
Man,
don't finalize till returnable debt.
Man.
It's already done,
My lord.
we cannot help it out, right?
My lord.
We'll just provide that.
But my brothers admitted, ma, these are not the part of the SBD.
Okay.
My lord, this document 39 and 40 is not part of the SBD, my lord. Now, one thing is very clear. Now, my lord, second question comes, my lord, this guidance issued by the finance
Interpretation.
department.
Will
Yeah.
interpret,
What will happen, my lord? At the most, they will not finance, that's all, my lord.
it's okay. Heard Mr. L. Lampu, learned counsel. H. Lampu, learned counsel for the petitioner. And also heard Mr. R.H. Nabu, learned additional advocate general for the state. For all,
Yes, all
no, 1, 2,
Private
3,
is there.
4,
5, my lord.
1, 2, 3, 4.
My lord, 1, 2, 3, 4, my lord. Yes, sir. Private respondent.
1, 2, 3, 4, my lord.
Yes. 1
Next
to 4,
para.
my lord. Yes. 5 is private respondent.
The challenge made in this writ petition, challenge made in this writ petition is the decision of the tender selection committee that is 29/02/2024, recommending the respondent number 5, I Messrs FB Enterprises for award of supply of free school kits in terms of the NIT dated 15/01/2024, issued by the Secretary, Women and Child Development Department, Government of Arunachal Pradesh. The learned counsel to the petitioner, referring to the office memorandum dated 21/04/2024, submits that since the lowest evaluated bid has withdrawn his bid, the authority ought to have retendered ought to have issued retender for procurement of preschool kits. Stuff. Having not been done, the authority has felt illegally decided to award the contract to the respondent number 5. In violation of the said office memorandum dated 21/04/2024. Next paragraph. Mr. R.S. Nabab, learned additional advocate general. Submits that submits that the applicability of the office memorandum dated 21/04/2022. Has not been established in the tender process. As the petition, the learned counsel for petitioner has admitted that said office memorandum is not a part of the standard bidding document in the present tender. Mr. He further submits that assuming that the said office memorandum is applicable in the present matter, come on. It is only on the two contingencies, that is, if the lowest evaluated bid withdraws or whose bid has been accepted, fails to sign the procurement contract, or fails to provide the security, then only the retender has to be done. Mr. Next paragraph. Issue notice returnable by 3 weeks. Since there's a respondent for 1 to 4 are duly represented. No formal notice needed. Serve however extra copies be furnished to ensure. The learned counsel for the petitioner shall take a steps for service of notice upon respondent number 5, where registered for so and so. Next paragraph. Are the interim hard on interim prayer. Next. On perusal of the office memorandum 21/04/2022. And the manual at page 38 and the part of the manual at page 39, at page 40. Come on. It is which it is noticed that the amended para states that if the bidder whose bid has been found to be lowest evaluated withdraws or whose bid has been accepted, fails to sign the procurement contract as may be required, or fails to provide the security as may be required for performance of the contract, or otherwise withdraws from the procurement process, the procuring entity shall retender the case. Please stop. On perusal of the above, I'm of the prima facie view that if the lowest evaluated bidder withdraws, the authority is required to retender the matter, retender the case, considering the above, till returnable debt. No final order shall be passed by the tender selection by the authority, if already not passed.
My lord, there is one letter, my lord, award letter, my lord. There is one award letter, my lord, which is also, my lord, impugnated.
It has been already awarded.
Award
Yes, my
letter.
lord.
Letter is
Then
there. One
it
letter.
will give
is
lots of trouble, my lord.
And
Then you lordship may change the order. my
But
lord.
there is only letter. Kindly see, my lord.
Anyway,
It
it's
is.
acceptance letters,
Kindly
my
see.
lord.
Where it is?
My lord, next. My lord, this phase 37, my lord.
37.
Yes, my lord. 37. And refer to the subject and communication mentioned above and arrange to
So we'll
supply.
see next date.
It's a long time back, 13 March, my lord.
But,
We are in April.
But my lord, this documents had
Although-
been furnished to me on 26th.
We'll see. It's already has been issued. This is of 13 March.
13 March.
But
We'll see next date.
look, kindly, my lord.
You filed on the next date, you file that thing, we'll finish.
Either
on
we
that.
file the affidavit or we'll take the instruction.
We'll see, then, we'll then in that case issue notice returnable at 2 weeks.
My lord, kindly, my interim prayer, my phase.
What is your interim prayer?
Interim prayer, my lord, to stay this month. This impugn order, my lord. This later, my lord. This later, my lord. My lord, kindly see, may I read this letter, my lord? Only letter has been sent to them, not finalized.
Although this court primacy finds that the matter, the authority ought to have retendered the case, in view of the order, or the letter issued by the authority dated 13 March 2024. To submit the offer letter, what did this say? Is it for
To submit documents, certain documents, my lord. Project-wise delivery challenge of PSK in the format prescribed with other letter may be submitted to the undersigned as per term and condition laid down in the department offer letter of even number dated 11 March 2024 for the partner necessary action, my. Paperwork is going on, my. But
no, by
support-
this time it might have completed. It's of 2013,
My lord,
13 March,
my lord,
20 days back.
my lord, this, my lord, this decision of the my lord, tender evaluation committee, my lord, it ought to have been, my lord.
It's a supply
uploaded
of
in-
preschool kits.
Kindly say when this was furnished to me, my lord. This was furnished to me on this 26th of this month only, my lord. And it was never uploaded in the web portal of the department, my lord. They are hiding, my lord.
May
And
I
I have
suggest one
obtained
thing, my
it
lord?
through RTI only.
It's not that you are only for retender.
Yes, ma'am.
It's not that your case that suppose if the respondent number 5 is not entitled, you could have been appointed. It's not your case. So in view of that, will not stall this.
My lord, till returnable that, my lord. Let's give 2 weeks, my lord. Till returnable that, my lord. 2 weeks, like 2 weeks, my lord. Because otherwise, my lord, so more, my lord, third party interest will be generated, definitely generated, my lord. And my lord,
No, where the respondent number 5 is not before us. We'll see.
respondent
next
5,
that.
I have made 40, my lord.
Huh?
Respondent number 5 was 40, my lord.
It is provided that the status quo be maintained.
Is on today. My lord, that will
We'll see on next day.
Next date, my lord.
On the status quo as on today, my lord.
May not say that also, my
One
lord,
month.
because, my lord, when you see, my lord, greater public interest, because you say school kids, my lord, instruments.
Oh, my
Kids will suffer, my lord.
Short date.
Because you are not going to lose anything. It will be suffer will be the kids, my lord.
What is the last order? The last line? Oh. No interim relief can be granted as it stays in view of the fact that tender relates to supply of preschool kits. Yes. However, the award or public tender shall be subject to outcome of the writ petition. We'll try to finish it up next day.
As early as possible. My lord, otherwise, my lord.
But I have recorded my prima facie view.
That is so much.
If we make it absolute, you may have a chance to participate.
Otherwise, my lord, the status quo will not, my lord, hamper.
Preschool kids.
Oh, my lord.
Just fine tune the.
May to your worship. My lord, this order was passed on 5/2/2024, my lord. So it has become more than 2 years. Yeah, my lord. Yeah.
In respect of Aya village or
Yes. Yeah.
that same Dibang Valley.
Yeah. So my
Sir,
lord,
I cannot
my
take up.
prayer is that my lord, time has already expired, my lord. I may be given, my lord, another more chance to issue fresh steps.
No, there's a difficulty appeared in related matter. The Aya village, same Dibang Valley project, compensation. So it would not be a proper mode to take up this matter before any other appropriate.
I think notice can be issued, Your Lordship.
No, if I cannot take it up, because tomorrow they may jump on me. List this matter before any other appropriates without me.
Next week on.
You make a mention somewhere in the other
Right.
bench. You may make a mention in other court. There's a difficulty. Number one. Yes.
Lordship, the respondent, they are not filed.
Why?
The affidavit.
Compensation appointment will direct. You appoint. Hmm? Who is power department? But you are the government. Listen, it's a compensation appointment. You appoint. Will directing you to appoint. Will not say direct you to appoint. You consider why you just whether he or she is entitled or not. You consider and decide. Heard Mr. R. Ingo, learned counsel for the petitioner. Also heard Mr. L. Permit, learned standing counsel for power department, and also Mr. I. Ram for state. Learned additional senior government advocate for the state. For other respondents. Having considered that, considering that the matter relates to appointment on compensation ground, the learned counsel for the standing counsel, Mr. L. Perme, is directed to file affidavit within 2 weeks from today. 2 weeks or 3 weeks? 3 weeks from today. List after 3 weeks, on which date the endeavor shall be made to dispose of the matter. Item number 2.
Wait, Vigilance.
Yes.
My lord, this is regarding non-payment of pensionary benefits. Affidavit has been filed. This can be disposed of.
Instruction. Already paid.
Paid.
No.
This is unnecessary. This is been sent to the first wife of my late father, who was already remarried. The affidavit
Earlier also these notices were sent, unnecessary notices. They're trying everything not to pay. The affidavit itself reveals it. They should have paid 20 years ago. This is the divorced wife of the petitioner. No, petitioner's late father. Unnecessarily seeking successful certificate.
Who is Lekan Chandra Chetia? Who is?
That's my grandfather.
Who is opposing?
No.
Huh?
No. Family pension in any case, he is not entitled.
Why did you send to the petitioner?
It's unnecessary they are doing it. I have made a claim, they are sending it to my grandfather. I don't know if he's alive or not.
Well, what for? Let them send to you only. You
No,
send
my
them-
lord, they are denying. They have filed an affidavit saying all sorts of things.
Is it?
Unnecessary things, yes. That this Lekhan Chandra's name is not in the same spell.
Dipti Sharma.
Dipti Sharma is my late father's first wife.
Huh.
She has remarried. She is
Okay.
not entitled.
Why you are not sending to the petitioner?
I have submitted documents that he is not sending to me, he is sending somewhere else.
What is this? And you are in affidavit, you are saying what they are saying.
Well, in affidavit, my
They are
lord,
saying that you are not entitled.
they are saying the documents are not, from the documents we cannot ascertain whether I am late Mahananda Chetia's daughter.
You consider whatever documents it is. You
Successor
consider that if
certificate is there, my lord.
according to you, if it is not as per the requirement, why you are not sending to the this petitioner?
From the affidavit, it is evident the DFO does not want to process my file. As simple as that.
So here also, they are either sending to the grandfather and the mother.
Who is remarried. Otherwise, my lord.
What do you say?
I was born 2 months after my father died. In terms of the rules, I am entitled.
You remember those?
I remember nothing because I was born after he died. My uncle took care of me. There was an attempt to have the pensionary benefits in my favor, but the deputy commissioner then advised that you get succession certificate. After 18 years, I could get succession certificate from the district judge at Bomdila. Thereafter, I have tried to process it and they are just denying it. Pensionary benefits, my lord. I have an elder sister, she's married, and she has given a no objection certificate also. I've just stated everything in the petition.
You have filed a rejoinder also.
No, it's not necessary, my lord, because the affidavit does not disclose much.
Okay. You don't want to file.
No, I don't want.
So we'll
That-
hear it. Or you want to advise your authority? So he's in conflict with you.
Maybe because
as submitted by him.
it's done,
The
maybe the
authority doesn't
DFO,
want to pay her or pay him. Pay her.
DFO does not want to do it because maybe he's thinking 22 years, I will have to pay all that. Maybe that's the thing. But I'm entitled to that. Even if there is no nominee.
You just submit, we'll dispose it.
Yes. 45, 2 minor B provides for if a government servant dies while in service.
Where it is?
That's gratuity. Page 25 it starts. The 2021 rules. Then your lordship will kindly have page 28.
Yes.
Retirement gratuity and death gratuity. B. If a government servant dies while in service, the death gratuity shall be paid to his family in the manner indicated in sub-rule 1 of rule 47 at the rates given in the table below. My father served around 20 years.
20 years.
20 years, yes. That is, I will show from the biodata. 47 provides how it has to be done. If there is no nomination also, it should be paid equally to all the family members. My elder sister is not claiming anything. Both, my mother is remarried. My father's first wife is also remarried. Now, your lordship, kindly come to family pension at page 31. My lord has, in fact, dealt with similar matter earlier also.
That Mizoram matter.
Yes. Rule 50, family pension. My lord knows 9A2. Unmarried daughter, my lord.
50.
Yes, 50A2 at page 35. 59(2). 50 is at page 31. Relevant is at page 35, 9(2). In case of a daughter other than a daughter suffering from such and such, excluding such and such, or divorced and not earning her livelihood.
Where it is?
At page 35. At the very top, in case of a daughter other than a daughter suffering from mental physical disease, including adopted daughter, stepdaughter, and daughter born after retirement of the pensioner, unmarried or widowed or divorced and not earning her livelihood. I'm unmarried. I'm only 20 years, 22 now.
It's okay. Let's see. I think
Yes.
I passed a similar order.
Yes.
And dealt to it.
My father, my lord, I was born on 2/10/2001. 02/10/2001. My father died 2 months before, prior.
02?
02/10/2001. My father died on 16/8/2001.
16/8/2001. Okay.
Because in respect of minors, family pension has to be paid through the guardian. That is also there in the rules. But that has not been done. That is, my lord, 59F. 59F.
Then also you are claiming.
Yes. Should have, my lord, they should have paid when I was a minor.
What is the 59F then?
Then, my lord, 45, death gratuity. And the manner in which it has to be paid is page 40, rule 47.
47.
Even if there is no nomination.
Mhm.
Then 59(2) and 59J. J, I'm just pointing out, they should have paid. 59A2. Succession certificate, my lord, is at page 46. It was granted specifically for this service and pension benefits.
Page 46.
46, ma'am. Serial number 3. DFO, Kelong Division.
Do you have that judgment order passed by the
Earlier
court?
one.
Ah.
I will provide, madam. I will just.
Have you seen it? I think it's almost same.
Yes, only thing here I will enter to death gratuity also.
Death gratuity. There was only
That was only family pension.
pension.
Yes.
Just wait. You provide, do you have
Yes,
now?
yes, I don't have it now, I will provide.
Just wait. So your claim here is family pension as well as the
Death gratuity.
death gratuity.
Yes. That's what I was trying to point out. Para 5, they have said, the instrument makes to state as per service record, date of birth of late Mahananda Chetia is 22/02/1960. Date of appointment is Forest Guard 18/2/1980. So 20 years. I have served.
Just where it is?
Paragraph 5 of the affidavit.
Affidavit.
Yes. It says nothing. In fact, they have given the record.
2, 3, 4 and 2, 3 and 4. Affidavit.
Yes, he is pointing out 5 only. There, this I am not aware of. Date of appointment Forest Guard 18/2/1980. Date of death 16/8/2001. Service of official terminated with effect from 10/1/1985. Service reinstated with effect from 25/9/1992. So this I was not aware of. But in any case, they have reinstated me.
No, this is the reason. I think you want to file an affidavit, additional affidavit. So
No, my
you
lord.
record that whatever stand they have taken.
This,
Suppose, see, for example, wrongly or rightly.
My lord, what I'm saying is,
yes,
let them give it in terms of these records. Because the petitioner is not aware of anything, my lord. She was born after she died. He died. I have inquired actually.
In
So
terms of
whatever,
this,
whatever.
you agree to that
Yes.
if it is paid in
Yes,
terms
yes.
of this.
Whatever they have
13
count,
years.
yes, whatever they count. Length of qualifying is 13 years, very well, because 13 years also.
Are you saying in view of this, she is not entitled?
No, no, so they are not saying that. They are not saying that.
You are saying that in so 13 years and 19
Yes,
months and 4
very well.
days also, on that basis also you can pay?
Yes, yes,
There's no bar.
yes.
Isn't
11
it?
years to 20 years, 20 times the emoluments. I am fine with that. That gratuity.
So it is not the rule, what the rule provides, if not 20 years,
No, my lord, that
even
gratuity.
if it's not 20 years, you are entitled. Are you
Yes, yes.
entitled?
Even after less than 1 year, 2 times of emoluments.
Okay,
11 years or more, but less than 20 years, 20 times of emoluments.
okay. So
Rule 45.
he said even if it's not 20
Yes.
years, by this, this 13 years so and so, you can
Yes.
just. So I'll
Because-
record this and even then you're only pointing out this only because of this 13 years and 9 months, qualifying years, right? It doesn't mean that she's not entitled. We'll record, I'll recording it. I'll be recording it.
Because the petitioner is not in a position to clarify all this. He was born after he died.
Okay.
I will provide the judgment.
Dispose of writ petition allowed
All right.
on consent.
All right.
Sir, on consent.
Item number 3.
May I please, Your Worship?
Yes.
Your Worship, in this case, Your Worship, I was supposed to file rejoinder, Your Worship. Therefore, Your Worship, some time
Yes.
has been done, Your Worship.
What do you want?
For filing rejoinder, Your Worship.
Mr. So-and-so learned counsel for the petitioner. Petitioner.
Yes, Your Worship.
Praise for is granted 3 weeks time to file affidavit in reply. So any objection? Mr. Okay. We'll see. Mr. Arseke for respondent number 2, land constable respondent to present, and Mr. You just write Mr. Arseke for respondent number 2. Land constable respondent, Mr. D. Kamduk for respondent number 1. 1 and 2, you just write the name. Are present. This after 3 weeks.
Much obliged.
Item number 4.
Yeah, Your Honor. And I'm appearing on behalf of Mr. S.K. Diori. And on the last order, there was some status report that was still awaited on behalf of the respondents.
What is this? What is the matter?
Lordship, this is regarding the Lordship, inquiry Lordship, investigation Lordship. They have this deceased wife.
Seeking investigation by
Lordship.
CBI.
Lordship.
Any inquiry report, any inquiry made?
Lordship,
The other authority?
Lordship, last occasion, Lordship, we have placed this.
You file an
settled report.
affidavit. Or
For that,
MS,
Lordship,
TY, learned counsel, appearing on behalf of Mr. SK, the learned counsel.
Lordship, may I, Lordship, for that, Lordship, we need extra copies to serve this, Lordship.
You serve
Please
extra
the
copy.
copies.
Don't make, I request all of you, don't make a issue of extra copy.
Lordship.
And don't make it a mention before the court. It's, you have to understand, you have to ask her. For all learned members of the bar. Not providing extra copies, don't make a mention before the court.
Lordship,
It's, you have to settle among yourself. Yes. Petitioner seeking CBI inquiry.
No, my lord, the inquiry has been, case has been registered, inquiry has been done, my lord,
You file an affidavit. Mr. M. Kato, learned DSJ, and MS L. Hagelan, additional PP are directed to, are granted 3 weeks time to file affidavit in opposition.
keep your flag.
May I please, ma'am?
Yes, what is the matter?
So for actions of pleading is cancelled, it's completed. I have got the reply from the department. So the matter before the lordship is pertaining to the, this is service meter. Here in this case, I am serving in the RWD department as a treasurer. In the meantime, various many treasurer like me, who some of them who are junior to me has been promoted to the post of the draftsman. And
Who appears for the state? Respondents?
respondent, Mr. Trak was there morning, he appeared.
Mr.
Gitarak,
RWD?
RWD.
Yes. Where are these persons? Have you not implemented them as respondents?
Malab?
The persons who have been promoted,
Promoted. That
junior to you and promoted, are they not before this court?
yes,
You include them?
they are not before this court.
You
Because
implicate them?
no, my lord. My projected case is, my lord.
Yes.
I have no challenge to their promotion.
Yes.
My promotion could have been considered on the day when they were also promoted.
Yes.
Therefore, my prayer before this court is, my lord, limited that my case should not be considered. Why my case should not be considered on the retrospective effect when other my junior and the senior
Have
were
you
promoted?
been already promoted?
No,
No.
my lord. I have not been promoted.
Yes.
My case has not been considered. But despite that, I am not challenging to the person who have been promoted. Whatsoever this is,
Are you not saying that they are junior to you?
some of them are junior to me.
Then you made them a party.
But still then,
Suppose if there is no post,
madam,
if juniors are promoted and you have not been,
madam.
on what basis we will direct them to?
Basically, my lord, since the post to be filled up are available there, since the appointment promotion was not on the basis of the recruitment rule of the
That's
department.
the reason the promotion was not made on the basis of the rules. It's
My-
an illegal promotion. So you make them a party.
My lord, I must think over it, my lord. So far, my lord, my projected case is, my
No,
lord.
no, it's not that automatic. Suppose you are eligible and there is a post. It depends on the department and the authority. Even if there is a post, if they find that it is not required to be filled up, it's up to them.
My
You cannot compel them to fill up. Right?
my lord.
But you may have a case saying that the promotion the DPC conducted was rehearsed the role and your juniors were promoted and you have not been considered. You may have the case. On that line will consider. In that case, you have to implement them.
My lord,
Because tomorrow, if I find that there is no, if the government comes and say that we don't want to fill up this post, whatever has been filled up, we don't want to fill up more posts, then what will happen? If they are not before this part, before this, Just challenging that it was, the horse rule not be suffice.
My lord. So, my lord, in the above this discussion, my lord, let this matter be, my lord, least after 2 weeks.
Okay. On the prayer of Mr. C. Modi, learned counsel for the petitioner, list this matter after 2 weeks. Otherwise, this could have been disposed of today. Obviously.
Item number 6.
Mayor,
Yes.
The private respondent was given last opportunity today. On last date, the private respondent were given last opportunity to file an affidavit.
You have filed your affidavit?
Yes.
Okay. What is the matter?
My lord, the matter is regarding the registration of the society, registration certificate of the society.
Who appears for the private respondent?
Earlier on dated 905, Tison appeared for a private respondent.
Yes. El Paz. The heard Mr. So learned counsel for the parties. El Teni.
El Teni, yes.
Learned counsel for the prayer, and also Mr. I don't know, learned additional senior government for this state response. Next paragraph. This code on 0102/2024. Granted a final opportunity to the private respondent 6 to 9 to file their affidavit in position. Mr. Hubbard, as on that no contrary affidavit has been filed on behalf of the respondent number 6 to 9. Come on. So what is to be done?
My lord, this matter can be disposed of today.
There is nothing, this is dispute between the groups within the society. I mean.
Why don't you go to the civil court? Civil court is there.
Yes, my lord, we have already.
Suit is there.
Yes, that
You
also.
go there, you pursue there. What is there?
Yes, we
What
have
to
got
do
the
there?
injunction order in our favor, my lord.
Yes.
But the registration certificate is with the private respondent. It is in their hand.
You bring all these things before the civil court. What we are supposed to do?
My lord, our only prayer is to quash that
You
registration.
just cannot quash like that. The issue relates to as a disputed question of facts, and what is there is to be. You bring in all those things before the civil court.
My lord, may give another chance, another date.
argue.
In this regard. Yes, my lord.
After a week.
After a week, my lord.
After a week, after 2 weeks.
After a week.
After a week. On the prayer of Mr. El Teni, London Council for Deputation, list this matter after a week.
Item
number 7.
Who is respondent number 2?
My lord, Tourism Department.
Huh? Who is respondent number 2?
Yes, I'm sir.
Have you filed the affidavit?
Not yet, my lord.
Why?
Due to some domestic issues, my
lord.
Some domestic issues.
Why tourism department?
Yes, my lord, his petitioner is seeking employment from the tourism department only.
Why tourism department? Other departments
Yes, my lord,
have provided you employment?
yes, my lord, he had a degree in tourism, the petitioner, writ petitioner.
Okay. Why don't you file it?
Yes, sir.
Why are you not filing a counter affidavit?
No idea, my lord, but I'm just instructed by my senior counsel to just say to be
Who is your senior counsel?
in Pada, Nalopad.
Okay. What to do?
My lord, we need some more time to file affidavit.
Last opportunity may be given.
It's of 2022.
Yes.
It's okay. Not Mr. So-and-so, learned counsel by the petitioner. MS so-and-so, learned counsel appearing on behalf of Mr. N. Pada, learned standing counsel for tourism department. Tourism department. Praise for and granted 3 weeks time to file affidavit as a last opportunity. List after 3 weeks.
Deeply obliged.
Item number 8.
May, my lords. This matter may be disposed of, my lords. It's very simple matter, my lord. May.
You don't need you don't want to file counter affidavit.
My lord, on 2011-2023, your lordship has asked the respondent, directed the respondent to seek instruction, my lord. Now, they have not sought any instruction, my lord. Even in 16/8/2023, my lord. This honorable court was of the opinion to dispose of this matter, my lord, and directed the council to procure, my lord, instruction, my lord. DSGI, my lord.
Yes.
Alice, may I propose to one thing, Malad? Now, Malad, despite the several the correspondence made to the Malad, the authorities concerned, they are not taking Malad the appropriate steps. Now, Malad, at this stage, Malad, direction can be given to the deputy commissioner to liaise with the Malad these authorities. If they wanted to Malad acquire the land, that requisition or willingness may be given to the Malad, the deputy commissioner for initiating the Malad process for land acquisition process under appropriate provisions of law, Malad. And if not at all required, my lord, that land can be taken back by the petitioner, my lord. It is not known, my lord, whether at this stage the requiring authority is ready to acquire the land or not, my lord. This is not known, my lord. So therefore, my lord, at this stage, direction can be given to the deputy commissioner. If, my lord, the requiring authority wanted to acquire the land, that may be initiated after obtaining the, my lord, the requisition, my lord, as per the procedure as contemplated under the Right to Pay Compensation Act 2013, man. And the willingness, so many other things has to be followed, man. So
My lord,
therefore,
page 33, my lord. This, my lord, the estimate was made, my lord, under 4 heads, my lord. Page 33, my lord. Land, standing properties, forest products, horticulture crops. My lord. Now, it was forwarded to the OC 90 RCC, my lord, on 22 October 2018, my lord.
Who has filed the affidavit?
Or state.
What is the state of the state?
State also say, my lord, they have made the correspondence, but there has been no correspondence from the Union of India, my lord. So only direction will be given to the Union of India, my lord, whether they are interested or not, my lord.
So my prayer is very simple, my lord. I'm only praying, my lord, may I, my lord. A writ of mandamus shall be issued directly to respondent authorities, particularly respondent number 427, to take immediate decision to acquire the land of the petitioner by paying compensation as per the assessment valuation report, or issue no objection certificate enabling the petitioner to undertake developmental activities over his area of life. This is my prayer.
You
Simple.
are reading, by reading, it's very simple, appears to be very simple, but
Okay.
implication is huge.
My lord, what happened, my lord?
So it's not a simple prayer.
The properties in my left and right has been acquired.
When you read the 4 lines, it appears to be very simple,
My lord,
but
my lord.
implications is very heavy.
My lord,
So
on
you
fif-
give them another chance.
my lord, on
Take
15,
officer.
my lord, your lordship has earlier also given them a chance, last chance, my lord.
Another, it's okay, another. You find it out.
Yes, ma'am.
What is there? If they want,
Yes, ma'am.
we'll direct them to pay as per the assessment.
they want,
If they don't want, give it back, that's all.
My lord.
The property is with me, my lord. It is that I want to undertake.
Heard
But-
Mr. B.P. Learned Counsel for the petition. Also heard, you are for 1,
I am for respondent number 4, 5, 6, and 7, my lord.
4, 5, and 6, 4, 5, 6.
4 to
Mr.
7.
And Ratan for respondent number
3.
Learned Additional Advocate General for respondent number 1, 2, 3.
No, on 2 and 3.
2 and 3.
1.
Mr. D. Kamdu, Learned Standing Counsel for Science. Mr. M. Kator, Learned DSJ, appearing on behalf of the Union of India, is directed to obtain instruction as to whether the respondent is ready to, the respondent is in requirement of, is under requirement of the land in question. Mr. List this matter after
My lord, may 8 April. Only for instruction, my lord.
8 April will be too early.
Only for instruction, my lord. Because on my lord, on various occasions, they have been given
You
instruction. my
just
lord.
have, try to have a telephonic,
Fair to make submission. In fact, telephone call was also made in presence of the my lord counsel for the petitioner. My lord, in fact, on several occasions I made.
you try, we'll try it.
After 2 weeks, ma'am.
After 2 weeks,
Good.
just after 2 weeks.
God bless you.
Deep level.
Item number 9, 10, and 11.
Yes. Yes,
Otherwise, matter, rule may be issued and matter may be fixed for hearing also. Pleadings complete.
you will, no, you will not do anything. This is what matter is
Uh,
regarding.
13-month lordship.
Huh?
13-month salary they ask.
Non appears to the petition on hold. Mr. Estapin Learned, senior government advocate, present. List after 4 weeks. If they are not interested, why is it? You have filed the affidavit.
Already.
No, he is present and submitted that he has filed the affidavit in opposition. He has already filed the affidavit in opposition on behalf of the state respondents. Yes. Yes.
Well, Your Honor, I may be given 2 weeks time to file my reply, my lord, to affidavit filed by the respondent.
What's the file? This is also a
This is
compensation.
compensation, my lord, this is a bit complicated, my lord, different. Now, what happened, my lord, in the 1450 acres was acquired by the respondent authorities.
So you want to take out something which they don't want.
No, the measurement was made as by way of compass, my lord, chain and compass, my lord. Now, what happened again? There was a dispute over the land, my lord. Now, measurement was taken.
If it is a dispute, you go to the civil court.
No, my lord, the assessment was carried out, my lord, and where it was found that 198 acres is extra with the respondent authorities. Now, we are
What is
saying
to be done?
you vacate the land or you acquire the land. After vacating some religious area.
By the army.
Yes,
army,
my lord.
army authority.
Yes, sir.
Do you
Assessment was carried out by the district administration as well as by the Indian Army.
do we try to realize how difficult conditions they are in?
My lord, I
In a
may
district,
not say
in
that,
a
but
area like Tawang and all these
yes, my lord.
border areas.
I was there, my lord. Well, your
That's-
lordship was
that's
also
why.
there, my lord.
You should understand,
Yes, ma'am.
all of us.
My lord. But, my lord, the land of the, my lord, this villages, my lord, it has to be also considered, my lord. Tawang does not have, my lord, good amount of land, my lord, which are
okay.
cultivable
But
or.
Mr. B. Pitcher, London Council for the petitioner. To praise for 2 weeks time to file affidavit. In reply. Praise the Lord. Mr. D. Kamduk for. London Council.
Respondent number 6 and 7, madam.
You have filed it already?
No, my affidavit will not be
No,
required.
and
Yeah, I will-
Mr. I. for all other respondents. Tell the name of the response, number of respondents. This after 3 weeks.
Mal, oblige.
Item number 13 and 14.
But the matter pertains to denial of NOC by the Deputy Commissioner Xiang
Hmm.
to the petitioner. And now, because of this denial, already 2 to 3 DPCs were held, and the case of petitioners has not been considered. The only reason for denial of NOC to the petitioner is that while he was in charge, additional Deputy Commissioner Jumlo Mawag Milot, he issued 4 number of LPCs, and which was later on evicted and subsequently it was cancelled. Milot. Now, that cannot be ground for withholding the issuance of the NOC.
Yes. Is it the ground for withholding the NOC?
My lord,
He has issued an LPC and that later on this has been cancelled.
no, my lord. This, we have a,
If you don't agree, we'll hear him.
yes, my lord.
He's not agreeing. I do agree. That cannot be ground for
Correct.
NOC.
But what I am saying, kindly come to my additional affidavit. I'll show you. I'll show this court, Milord.
No, you argue. We'll dispose it of matter. Or we'll fix it for hearing.
No,
Are you taking time?
No, Milord.
If it is, if
It has to
if
be-
you take another 1 hour,
No,
we'll fix it for hearing.
I'll finish it in 10 minutes.
Huh.
Let him take another 5-10 minutes.
Okay.
Huh.
Finish it.
So we finish off. Milord,
Why this body matter are listed together?
Same.
Well, I am telling the notification itself, my lord.
Okay.
Because
You are
the
on la-
notification
you are
does not have
on
any
la-
force of law, my lord.
Correct.
Larger issue.
Yes, my
Larger
lord.
issue.
It does not have any force of law.
So we'll hear him first. Anyway.
It will always be pleasure if my younger is given the opportunity. Because he has been trained by me, Milord. I'm so proud that
this court prefer to give opportunity to the younger.
correct, Milord, because I'm so
Younger
happy
lawyer.
that the young, anyway, Milord, kindly see that page 18 first.
10 minutes.
Fine, I'll place this record, nothing much.
Yes.
that page 18
Yes.
and 19, my lord, that is order, that is circular dated 8/6/2023, issued by Under Secretary Personnel,
Page 18.
page 18, my lord.
You are.
I am at serial number 4.
Yes.
Furnishing of document place a DPC that NOC, my lord, will see at line second last line. Furnish the NOCs and remaining APR if so and so, sir, 5 years. Now pursuant thereto, my type copy is at page 19, my lord, sorry. For legibility, my lord.
You are APCS.
I am APCS,
APCS what?
senior grade. my lord.
Senior grade.
Yes.
Yes.
The age. Now then what happens is I submitted my letter to the Deputy Commissioner requesting for issuance of no objection certificate on 8 June 2023, my lord. This has not been acted upon. Annexure 2, page 20, my lord. Kindly come to page 21. Next. Now this ADC, my lord, is the one who is creating problem for me. Then pursuant to this, file was endorsed to him and he further wrote to the circle officer Jumla Mogo to examine whether I am entitled to get this or NOC or not, my lord.
Yes.
Now, page 22, my lord, annexure 4, 16/6/2023, this is forwarding letter, submission of verification report. The verification report, my lord, is at page 23 on the same day, which I fairly admitted that while I was functioning as in charge ADC, I have issued 4 provisional land possession certificate. That is 1, my lord, 2, my lord, and 3.
Very serious.
Correct, my lord.
Your mother's name.
But, my lord, for that, there ought to have been departmental inquiry.
Anyway.
No proceedings against me. Now, my lord, kindly come to next page. Page
Dead wife, mother, wife.
Absolutely, my lord.
Obvious.
Obvious.
Is obvious.
Is obvious, my lord. At least there should have been some disciplinary action. Now.
And your own name.
Yes, in my own name, my lord. Very unfortunate, my lord. I cannot.
Unfortunate, but obvious.
Obvious, then I cannot defend the indefeasible as well, my lord.
Yes.
Well, then reminder letter to the Deputy Commissioner pursuant to my letter to issue NOC. That is dated 26/2023
Yes.
at page 24. Now, my lord, there nothing was forthcoming. Then this page 25 is my WhatsApp communication with the Office of the Deputy Commissioner. Now, my lord, kindly come to this page 27. This is very important, my lord. 26/2023, on the same day, it was the circle officer forwarded to the Deputy Commissioner, additional Deputy Commissioner regarding verification. My lord, kindly allow me to read this particular paragraph, my lord.
Yes.
I am reading from 3rd paragraph, my lord. Further, it is pertinent to mention here that on 11 circle of 11/3/2023, an eviction drive was carried out by the undersigned in which almost all the illegal structures over the government land in and around Jomlo Mobo government areas was removed, demolished, and detailed report was submitted before your good office. But as per the report of CEO Jumlo Mobo, it is found that the government land stroke property areas have been re-encroached by erecting refence with barbed wire under the mastermind influence of Sri Thagam Mivang with an intention to occupy the land permanently in the name of so-and-so, 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 thereby obstructing the legal process of our administration, my lord. Fairly admitting, my lord. Therefore, under the above fact and circumstances, the DC Boleng may like to review this report before issuing NOC to. My lord, the reason for writing this letter, I will demonstrate at later point of time, because these gentlemen also issued certain LPCs, which I have categorically alleged in my read petition. He also issued certain provisional land allotment certificate within that. Now, my lord, then this, I was asked to make a reply to this. My lord will kindly come to page 28 for a moment. Deputy Commissioner, in reference to your letter number dated deal so and so, so I am to inform you that ADC Rumgong, your controlling officer, has raised some observations and objection against you. You are therefore hereby directed to take necessary corrective actions wherever applicable, or the observation raised by the ADC Rumgong after taking this. Then what happens, my lord? Page 20, my lord, kindly come to page 30, this type copy. Annexure 6, my lord. Now, these are the justifications that I have given. Now, after reading this, my lord will find that there is a certain ego tussle between the ADC Rumgong and by the petitioner. Whereas both of them are from the same cadre. They are APCS officer. But this clarification is given. I have given everything, my lord. Now, this is I have submitted. Now, my lord will kindly see what he writes, my lord, at page 34.
Yes.
Here. Now, forwarding of reply by Tagam Mibang, so and so, your letter. I propose to the subject and the reference letter number mentioned above, Sri Tagam Mibang of Rampa village, the then CEO in charge of Jumla Mobok Circle has refused compliance to the order of DC Siang. Instead, he has written a reply to the office of the undersigned stating his reasons of non-compliance. Also, he has mentioned few PLS issued by me and my predecessors in the letter. The PLS issued by the undersigned predecessor ADs were issued with all causal formalities and to none of my relatives. All allegations made against the office of the undersigned holds no legal standing. This is. And thereafter, my lord, I again wrote back, the petitioner again wrote back to the Deputy Commissioner, and he has given all the clarifications, my lord. Now, second paragraph onwards, my lord.
What is this PLA?
Provision land allotment.
Provision land allotment.
Yes. My lord, there is no concept, my lord is aware. Under the 2000 Land Settlement Act and Acts, there is no provisional land allotment system.
Anyway, the additional DC, Deputy Commissioner is not, he doesn't require NOC. You are the one who,
yes,
who need
correct.
NOC.
Absolutely, my lord.
Anyway.
Then what will happen, my lord? Kindly come, then all those correspondence I'll not reiterate much, my lord. Kindly come to page 40, that's annexure 10. Now, my lord, here I have clearly written to the Secretary Personnel, Government of Arunachal Pradesh, with a request that with or without the NOC, my name should also be placed in the DPC and the seal cover procedure should be adopted. But this has not been done, Lord.
Yes.
Now, my lord, kindly see, kindly have, for a moment, kindly have my additional affidavit that I have filed. Affidavit in reply, my lord.
So, that means the ADC,
correct,
after verification found that you have issued LPC to you in the name of your mother, wife, and yourself. So they, according to them, you have encroached the government land. They want you to do some corrective measures, to take corrective measures, surrender or whatever. You said initially that you have issued a LPC and that is cancelled. Where it is?
Then
where it is?
Finally, it has been.
Where it is?
It has been done away.
Where?
Kindly come to my affidavit in reply, page 10.
Page 10. Reply?
Yes, ma'am.
Reply to?
Rejoinder filed by petitioner against the affidavit in opposition filed by respondent number 2 and 3.
Just wait.
All the land possession certificates are there. Will not kindly come to page 10 straight.
Affidavit in reply.
Yes, page 10. Malad.
Page.
Yes. Well, it says order dated 10 March 2023. Whereas report has been received from Additional Deputy Commissioner Rumgong, Siang District wide number dated so and so 9 March 2023 to the effect that encroachment of government land at Jumlo Mawak Circle headquarters under Rumgong subdivision of Siang districts are taking place after issuing provisional land allotment to some person on 15th February 2023. Whereas the copies of provisional land allotment detail and particulars of the allottees area in square meters allotted to each allottees, recommending officer, issuing officer, and the date and period during which it has been issued have also been examined. And whereas it is apparent that 4 no's of provisional land allotment order issued, white number dated so and so, 15 February 2023 is illegal and not as per the procedure of allotment process in the government land and hence are liable to be quashed. Therefore, the aforesaid provisional land allotment order stand cancelled with immediate effect. Now, my lord, what remains? After this cancellation, what remains against me, my lord? That is the moot question to be asked. Whether rightly or the wrongly LPC has been issued and thereafter you have cancelled it. And if there was any further re-encroachment, then that Public Premises Act is there very much. You can initiate against me. And there, secondly, the second option which they would have was to initiate departmental inquiry proceeding against me. Nothing has been done, Lord. Now, these cannot be the ground for denial of NOC, thereby to turtle my opportunities of promotion. So therefore, my lord, the sum and substance of my argument to an extent is that to direct them and direct the Deputy Commissioner to issue NOC to me. Without malice and prejudice to the rights of other side to advance argument, but at the same time, such action, my lord, to my understanding, is deprecable because the action of the ADC and the Deputy Commissioner in denying NOC to me is opposed to the law. Oh, my lord, at 2, my lord. It's already 1-5, my lord. Sorry to detain, my lord.
Yes, good.
At 2 minutes, another
This
2
is
minutes.
10 March 2023.
Can-
Then, when did you file this writ petition?
That repetition, my lord, there's, my lord, may kindly call for the, then these impugned cancellation order is under challenge at WPC number 157, 2023 and 156, 2023.
This under challenge?
This is under challenge.
Which challenge? You are challenging?
Yes.
No, you said the LPC or whatever allotment order which you have issued, this has been cancelled.
Cancelled.
It's under challenge. That
But there
means
is-
you are still thinking that whatever is allotted,
No, but-
I mean, whatever you have, the allotment order which you have passed is still in existence.
No, remember, there is no
Still,
stay.
you, according to its valid. According to the authorities, you have encroached the government land and it has not been as per the norms or the procedure. That means how can they issue you a NOC?
No, my lord.
The requirement for promotion to obtain a NOC from the district under the law
I'll
is
explain.
one issue.
I'll explain to this.
There is one issue, another issue.
No, my lord, the corollary, as an example, is that
15 minutes.
yes, my lord, therefore, my lord,
We'll resume it too.
Your Honor, if I may please, Your Honor, I wanted to mention one item, CRP 10 of 2024. Yesterday, I had made a mention before this honorable court, but I was asked to mention it before the court number 2. And accordingly, it was done and it was listed. However, because the first day of motion, the order was passed by this honorable court of notice, Hence, the moderation or the alteration can also be made by this honorable court. That is why it was said that.
Make a
that should be
mention
mentioned
tomorrow.
here.
Tomorrow. Make a mention tomorrow.
Yeah.
We'll see tomorrow.
Lordship, item number 32 might be taken after 2 weeks, Lordship.
We'll see. We'll wait for your turn. You wait for your turn. We'll see.
But I'm there in the other side. I'm there in the other side. Item 32.
Well. Let the matter come.
Yes.
4:30, we'll see.
So, my lord, fundamentally, my lord is clear with the fact.
Clear the fact that you have issued an allotment order, though it has been cancelled by now, in the name of your mother,
And
wife,
mother and the wife.
and yourself.
No. The mother and the wife, they have put to challenge this because the Wednesbury principle was not followed in this case. Only on that ground only that impugn cancellation order was done. Now, my lord, the larger question comes now. Now the larger question comes. Once a order is good or bad has been issued, unless it is not modified or it is not cured by a judicial process. Now, two situations. First, the executive orders, you have cancelled my temporary land allotment. One. Secondly, though that impugn cancellation order has been put into challenge, this honorable court has not granted any leave. Therefore, the order of the executive that passed cancelling my LPC still holds the field. So therefore, there is no infirmity. And on that basis, you have the power to initiate action against me, but you cannot blow hot and cold in this matter. Now, the second question of law, Miller, that I'm arguing now, is that they are completely depending on this visual manual, Miller, vigilance manual, which has been put into challenge. For the reasons, Miller, kindly have the Constitution for a moment, Article 154, the executive power of the government, state. Now, under that, the power is vested through the cabinet, headed by the chief minister, and then policy decision is taken. Then down below, the administration has to issue the order by means of executive actions. But these guidelines, Milord, Constitution.
54. Constitution. Get there, let him read.
Now, my lord, that my lord knows 166 has to be complied with.
Are you challenging that the manual?
That is in the subsequent, my lord.
I think you have not opened this book.
No, my lord,
You
this
have
is from
purchased
the,
it today
no,
only.
no, my lord, this is from this honorable court only. I have virtually stolen. Now, my lord, page 61. Article 154, executive power of state. 1. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. 2. Nothing in this article shall A. Be deemed to transfer to governor any functions conferred by any existing law on any other authority, or prevent parliament or legislature of a state from conferring by law functions on any authority subordinate to the governor.
Yes.
Now, that's one. Now, therefore, any decision by the cabinet ought to be taken in the name of governor. This is a notification, not even a simpliciter in the name of governor. This has no relevancy. If this has to be made applicable, my lord will kindly have Article 166 for a moment. Conduct of the business, my lord. Page 64, my lord. Has it, my lord? Yes. Conduct of business of the government of a state. All executive action of the government of a state shall be expressed to be taken in the name of governor. My lord, this starts with a non-obstante clause. My lord, for a moment, I demonstrate this particular.
Which one? 166.
166.
It doesn't start with the non-obstante
Yes.
clause.
Mandatory.
It doesn't start with it. Read it. 166.
Yes, I'm reading that.
It doesn't start with.
Yes.
You are amending the constitution.
No, sir, sorry, my lord. All executive actions of the government of a state shall be. Word shall is mandatory, my lord. I was supposed to use the word mandatory, my lord. Shall be expressed to be taken in the name of the governor. Now, this is a mandatory provisions, my lord. Now, my lord, I demonstrate one particular notifications from here. They might take shelter from here, my lord. Here, the procedures they have made is, my lord, even one particular notification I will show.
Where is the order of requirements of NOC from the Deputy Commissioner?
My lord, it is in the vigilance, my lord. In this vigilance.
Where it is? Have you annexed this? Have you annexed it?
have the extra copy. It would be in my petition.
It is in the petition, my lord.
Item 14.
Item 14.
No, item 14 will come back later. Come later.
But I saw it. They have this memorandum. Well, for example, this annex appendix 3. Office memorandum.
Visitor
Yes.
will consider your case grievance on the basis of your prayer. You read your prayer first.
Yes, Mother, I am aware of.
These are not your pleaded cases.
Mother, because
No way you have said
No.
the authority
Mother,
has
the connecting
the power to issue for seeking an NOC from Deputy Commissioner on the basis of this office memorandum. You have not said anything.
No, I have not said. This is part of the connected read petitions.
Then
When-
we'll hear that first.
Yeah, that's why I'm highlighting.
Are you appearing on that?
Yes, my brother.
You argue that first.
I'll
We'll
encourage
take
my
it up.
brother.
Your
No,
order is-
therefore, let me.
your only prayer is
I'll complete in one.
to issue an NOC.
Yes.
Direction for issue a NOC for consideration of your promotion.
Yes.
That's all.
And on my lord, on perusal of Annex 3 of this manual,
Yes.
office memorandum, my lord. I'll put across two arguments, a small argument in 2 minutes, and then my brother will take over. The first thing is that it is office memorandum. It is not issued in the name of governor.
Not
So therefore, my lord,
Not necessary.
therefore, my lord, Article 166, sub-article 3 has not been complied with. 1. Number 2, 3, my lord. My question, limb of argument is, these office memorandum, these are not mandatory in nature directory. Law is well settled, my lord. So therefore, my lord, by means of these office memorandum,
How do we connect
without
this
amending
office
recruitment,
member?
can you deny me the NOC?
Sir, how do we connect your petition and the grievance and this office memorandum?
I'm highlighting broadly a little bit about this particular item 14, which is connected where the entire notification has been put into challenge, my lord. So therefore, the broad argument, which I am going to hand over to my younger to advance the argument, he will place the citation. My lord, therefore, the broad question is, the first, when it is not taken in the name of governor under Article 154, and simultaneously it is not in compliance with Article 166, sub-article 3 of the Constitution, these order cannot be sustained. 1. Number 2,
This order of what?
This vigilance manual,
It's not under challenge by you.
it is here in the 14.
We'll go to
Yes,
it. You
but-
argue that better.
Well, I'm
When it
placing-
comes to that better,
Yes,
you
my
argue
brother
that.
will assist later part, my lord.
Okay.
Later part, my brother will assist me. So then I'm leaving this scope. The second question is, once it is not authenticated in the name of a governor, the order itself is authorized and it is not implementable. Number 3, my lord, which the question of law, which my brother will answer, my lord, before lordship in this particular item, is that without amending recruitment rule, by means of this office memorandum, you cannot curtail my fundamental right for promotion. My lord, that 1997 Ajit Singh 2 judgment, from where right for consideration of promotion has been recognized. With that conditions, my lord, here is a case in the first writ petition, my lord, you have cancelled my LPC. 1. Number 2, no departmental inquiry has been initiated against me. Now, where is the question of denying me the NOC? So as to enable me to submit before the Department of Personnel to get my further promotions. 3 DPCs have already been held. And over 2 months, my lord, I have not been promoted. My juniors have been promoted, my lord. In the most case, in my representation, my lord, I have categorically made a submission, my lord, that kindly put my name in the DPC, you adopt the seal cover procedure, my lord. But that also has not been done.
But you are not questioning the,
I'm
they
not
ask-
questioning. Now,
the
only directly.
requirement of NOC.
Yes,
You only want that NOC should be given to you
correct.
by the deputy.
Yeah,
commissioner.
correct, my lord. No, my lord, this is what I'm putting, how I'm agreed now. Because of denial of the NOC to me, I have been caused prejudice and irreparable loss in my service career. Now, all the questions that I have framed will be initiated by my brother. Very good, we start.
We'll segregate your matter. We'll dispose of your matter as per the grievances you put forward and as per the prayer of your writ petition.
Subject to the.
And we'll hear him, we'll decide his method separately.
Yeah, because, my lord, why it is interconnected? Because once his writ petition is allowed, then I need not to agitate also. Because all
No,
the
my lord.
particular clause will go.
Interconnected in the sense, my lord, factually, his case is different, his case is different. Now, the first case, my lord.
We'll first hear him on the first case.
Yes. What my learned friend has suggested, that his entire case is that the LPC provisional LPC which has been issued by him has been cancelled. Now, therefore, there is no question of withholding the NOC. Now, my lord will kindly come to page 27 of their writ petition. What they have read out, my lord.
Yes.
Further, it is pertinent to mention here that on 11/3/2023, an eviction drive was carried out by the undersigned in which almost all the illegal structures over the government land in and around Jomlo Mobuk government areas was removed, demolished, and detailed report was submitted before your good office. But as per the report of CO Jomlo Mobuk, it is found that the government land properties areas have been re-encroached by erecting re-fence and with barbed wire under the mastermind of influence of Sri so-and-so with an intention to occupy the land permanently in the name of Srimati Yatar Taga and Srimati Miti Parame wife, thereby obstructing the legal process of our administration. Meaning thereby, the land has been encroached. Earlier, the submission advance is that once the LPC has been cancelled, I'm no more an encroacher. In fact, when the provisional LPC was existing, he could not have been said to be encroacher. Without the LPC now being surviving, he still is in occupation of the land. That means he's an encroacher. Now, in that event, can NOC be issued? My lord? LPC, what he officially it was incorrect, he issued, but till that time he was legally obtaining, holding it. Now, after the LPC has been cancelled, he is an encroacher. So long as he has not vacated that land. So question of question of granting NOC does not arise. That is the moot question. And it to the
double AG to point out
Yes.
the remedies also.
yes.
If I am the encroacher.
Now, when you are a legally allotted person, can you be termed as an encroacher? Now, when you don't have that legal document, now you become an encroacher. To that point, he still, so long as he holds the land,
Yes.
he is an encroacher, and for an encroacher, NOC cannot be issued. Pure and simple in his case. Just because the LPC has been cancelled, that has fortified that he is an encroacher. First of all, the very land possession certificate which was issued to himself and wife and all, this was without following the procedure. Now, after the cancellation also, so long as he holds the land, he is still an encroacher. He is not authorized to. Cancellation is another part. He still is an encroacher, so long as he did not vacate. So in that count itself, he is not entitled to be given the NOC. In this case, I'll submit only to that.
Now, though he has not pleaded, why is the requirement of NAC
My lord.
Deputy Commissioner for promotion?
My lord, there is the vigilance, this guidelines, my lord, and also orders requiring for promotion that no encroachment is to be, certificate has to be given by the concerned deputy commissioners, my lord, that the parent department will seek from the concerned deputy commissioners. Now, this is a requirement for promotion, my lord. For considering, it is a instruction, my lord, order, executive order under 162. My lord knows DPC. DPC will be guided by the manner in which the DPC members wants to. But here is the government has come with a condition that one should not be having encroachment. So this, because under the DPC, under the recruitment rule, it says only DPC will consider. These are things which are not in the recruitment rule. These are filling up the gap of what is not there in the recruitment rules. It is supplementing, not supplanting the recruitment rule. So these are conditions by the government. Now he cannot, as a matter of right, claim that since there is nothing in the recruitment rule.
He has referred to Article 154 and 166.
No, my lord, that's why.
Therefore,
If my lord will kindly see that also.
Your office memorandum is not in terms of the 164, 154 and 164.
My lord,
According to him.
for that, because it is by the government, that is the policy decision by the government, there will be, my lord. Since these are not pleaded in this case, these materials could not be brought. Otherwise, just out of the blue, the government will not. There is a policy decision which are being implemented by the executive, and therefore the no encroachment condition, my lord. These are, and then this is issued by the chief secretary, my lord.
No, according to you, whatever his submission, that whatever this office memorandum, where this vigilance or this NOCs, the requirement.
There is
of
no
vigilance
pleading in
there.
such in this.
Otherwise also, it's
Yes.
a law point
Yes, my lord.
that without following the 154,
Yes, ma'am.
and 166, such an executive instruction order cannot be passed. Or a policy cannot be adopted or implemented. That is his argument.
My lord, that's why, to that effect, if we have the instruction, because otherwise, also already order has been passed, and that will be obviously that it is by way of a policy decision by the, that's why this has been reflected by the chief secretary and implemented by the chief secretary. Otherwise, without that, the chief secretary or the vigilance department on their own will not do. These are not pleaded cases, man. We will, if required, we'll bring that.
See, you have not pleaded because therefore he
No,
cannot
these are
respond.
question of law need not be pleaded. Once you formulate
But
the question of.
it has to have some relation. A connection has to be there to your grievance. It's not your case, even if it's not specifically pleaded, that the authority could not or ought not to have relied on the office memorandum, which is not issued in
Enforceable.
terms of the
Yeah, 150.
provision of the constitution. You have not said anything also. You have not said anything pleaded anywhere. This
No,
could have been
I agree.
suffice.
I agree, my lord. I agree.
Your only prayer is, in view of the cancellation of the order issued by you in the name of your mother, wife, and yourself, the NOC should be issued.
It is in a
You
name-
want that the NOC should be issued.
I want.
He said that since you have already encroached, still the encroacher, though that order passed by you, allotment order issued by you has been cancelled, still you remain as an encroacher. Therefore, no NOC.
Therefore, my lord, I respectfully differ with the submission of learned double AG that I am an encroacher. No. If at all I am an encroacher of a government land, you have a law, a specific law to deal with me. Without resorting that, you cannot, honest surmises, per se the presumption that I am the encroacher. That is not correct, my lord. On the sound public
So
policy.
if you want to amend the petition, we'll allow you. If not, we'll decide on the basis of your pleadings.
No, my lord, simply because that's why my lord, I am saying this particular second item 14, is connected. The entire office memorandum, I highlighted the sum and substance of the portion of law.
We'll dispose of separately.
Separately.
Well, hear him now and
Yeah, yeah, well,
dispose of separately.
In the
Not in as a common judgment.
That's fine, my lord. See, my lord will see. My lord will see two things.
Yes.
If my lord allows this read petition, the item number 14,
Yes.
then if my lord take a different view in my read petition,
Yes.
then still I will be the survivor for the fittest. I will have the benefit of that.
Let me see. Let this quote
My lord, in item, the next item, we
Yes.
have no objection, my lord. We have the latest one, there is no encroachment by the, so that on its own suffice, my lord. There is no requirement to go into this, in this.
When you come with bounty.
That's why I was saying, asking you.
Then, my lord, in my case, then kindly call for a status report from DC, whether I am the encroacher or not.
There is.
That only prayer I can advance.
In view of the instruction, I believe there will not be any necessary to go into the.
Yes, what do you say?
My lord,
You have not encroached and you will get the NOC.
Yes.
And the vigilance clearance.
Yes.
My lord, I have stated that there is no criminal case pending against me or departmental proceeding pending against me. My lord. And they have stated, they have not stated, they have stated nothing, my lord, in their statement, to my affidavit, my lord. In para 15, they have only said the answering deponent offers no comments, my lord.
Your case is going to be considered, don't worry.
No, my lord, for the last 36 years, my lord, I'm in forester, my lord. Now I am going to be retired, my lord. Due to this NOC and vigilance clearance, my lord, I was never considered, my lord.
What do you want to say? They said there's nothing against you. In that case, process will you'll be getting the NOC.
For the social benefit, my lord.
Huh?
For the social benefit, my lord.
No, this,
If your lordship may interfere with this notification, my lord.
in this case, we cannot. You may have you may approach, you may file appropriate petition for that.
I have challenged, my lord. I have challenged, my lord.
What?
This impugn orders, my lord, and notifications and circulars, my lord.
No, I'm saying in view of this instruction,
My lord.
since there's no enforcement against you, if you want to pursue the matter, will pursue, you may argue the matter. If not, we'll close the matter in view of this instruction. You will get the relief from them only.
My lord, what happened, my lord? They had issued the deputy commissioner had issued the NOC, my lord. Again, then for the vigilance clearance, my file was not processed, my lord. I will show, my lord. Let's go to the facts, my lord. May I, my lord? My
No,
lord,
no,
I
first you
joined.
decide. Once we hear you, we'll
Yes.
decide the entire matter.
Yes, my lord. Let's decide the matter.
What he's saying is, in view of this instruction,
My lord,
you'll get everything. You'll get the NOC and everything
my lord,
as sought by them.
my lord.
Since there's no enforcement,
My lord,
there's no
this
business-
judgment would be a landmark judgment from the lordship, my lord.
It's not a landmark judgment. It will not be.
My lord,
It's up to you.
yes, my lord. I will proceed, my lord.
Okay.
Yes, my lord. A law has to be laid down by this honorable court, my lord.
No,
Yes,
it's
my lord.
not that. Will depend on the grievance.
Yes, my lord. Now, the
grievance-
facts of the case, my lord. Yes, my lord. I joined as a forester on 15/6/1987, my lord.
Hmm. Hmm.
As a grade 1, my lord, forester, my lord. Now, there were grade 1, grade 2 forester, my lord.
Hmm.
Now, what happened, my lord? That would be at page 47, my lord. The
Yes.
first recruitment rule, my lord.
Yes.
Or page 46, it starts from page 46, my lord. This is the type copy, my lord. Original would be page 42, my lord. Page 46 will be type copy, my lord, and page 47 is the relevant portion, my lord. Initially, my lord, for the post, for promotion to the post of deputy forest ranger, my lord, it is by way of promotion on the basis of seniority come merit from amongst the forester grade 1, my lord.
Hmm.
I was a grade 2, my lord. So I was not in the zone of consideration. I can be seen at page 48, my lord. Anyhow, my lord. Again, my lord.
Hmm.
Now, what happened, my lord? New recruitment came into existence, my lord. Page 61, my lord. Came into force, my lord.
Hmm.
Page 60, my lord, would be the page 61 would be the relevant portion, my lord.
Hmm.
Column 12, my lord. Page 61, column 2. 100% by promotion from amongst the foresters. By this recruitment rule, my lord, this grade 1 and grade 2 was done away, my lord. This is the notification, this is the RR of, my lord. RR was notified on 8 April 2003, my lord. My lord is getting, my lord.
Hmm.
Annexure 2, my lord, page, it starts from page 53, my lord. The original portion, my lord.
Hmm.
The type copy starts from page 57 and page 61, column 12 is relevant to me, my lord.
Yes.
Yes, my lord. Now, my lord, page 62, my lord. The impunity order starts, my lord. 2 April 2013, my lord.
62.
Yes, my lord.
Hmm.
This is the, to my knowledge, this is the first notification, my lord. Order, my lord, requiring NOC and vigilance clearance for promotion, my lord. My case is for promotion, my lord.
Where it is?
2 April 2013, my lord.
Yes, yes. Page 62, yes.
Yes, sir. May I read, my lord?
Hmm.
It has been reported by the Chief Estate Officer, Itanagar Capital Complex, that there are approximately 3,000 cases wherein the occupants of government accommodation have either occupied those structures permanently or demolished to construct new buildings. Further, this action on the part of the LOT government servant is in violation of conduct rules and amounts to criminal offense under Damage to Public Property Act, for which the district administration can initiate criminal proceedings. On the other hand, there is acute shortage of residential quarters for the government officials on transfer. To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that vigilance clearance to government officials for promotion and settling retirement due NOC shall be obtained from the concerned deputy commissioner, clearly stating that the government officials has not encroached upon any government property nor has caused any damage or abated encroachment on the public property by a private person. This instructions shall be complied by all concerned. My lord. This is the first order, my lord. My lord, may I kindly appreciate that this order has not been issued by in the name of governor, my lord. This is a simple circular, my lord.
This vigilance clearance includes the encroach. You have to issue vigilance clearance separately.
Yes, my lord.
Separately, my lord, what happens, my lord, vigilance department, first of all, with regard to encroachment whatsoever or any departmental proceeding, it is the parent department who has to give the inputs regarding any officer. With regard to non-encroachment also. Now,
No,
when
it's
it
a-
comes to the vigilance department,
It is that it has been decided that the vigilance clearance to government officials for promotion and her settling retirement due NOC shall be obtained from the concerned deputy commissioner.
the department.
I think so far as the settlement of retirement is concerned, this code has
Yes, madam.
Settle the matter.
Because for settlement of retirement, it is under the pension rules, where the rule 8 itself provides that it cannot be denied until and unless there is a departmental proceeding, criminal proceeding.
Yes.
But for promotion, it is another thing, ma'am.
Yes.
Yes, ma'am. Then, my lord, page 63, ma'am. The another order, my lord. Impugn, this is also, I have impugned, my lord. 6 June 2017, my lord. It has been reported by the Deputy Commissioner, Eternal Capital Complex, that there are approximately 3,175 cases wherein the occupants of government accommodation have either occupied those structures permanently or demolished to construct new buildings. Further, this actions on the part of the LOT government servants is in violation of conduct rules and amounts to criminal offense under Damage to Public Property Act, for which the district administration can initiate criminal proceedings. On the other hand, there is acute shortage of residential quarters for the government officials on transfer. To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that vigilance clearance to government officials for promotion and for settling retirement due NOC shall be obtained from the concerned deputy commissioner, clearly stating that the government officials has not encroached upon any government property nor has caused any damage or abated encroachment on the public property by a private person. However, in the cases of retirement of officers on superannuation and in the event of NOC not being issued, this is related to officers who are retiring. My lord. This is not relevant to me. My lord. Last one, this instruction shall be complied by all concerned. This order supersedes earlier government order number so and so dated 2 April 2013. My lord.
Yes.
Yes, ma'am. Then page 64, my lord. This is also order which I have impugned, my lord. Page 64, my lord. In partial supersession of previous circulars in the matters of issuance of NOC for issuance of vigilance clearance for promotion, grant of MSCP, issuance of NOC for applying for deputation, so and so, my lord. Now, my lord, Roman 1, my lord, the following procedure shall be adopted with immediate effect. The vigilance report request clearly stating the purpose for which it is required shall be sent by an officer not below the rank of joint director, under secretary of the department where the official is currently posted to the under secretary vigilance. Now, by this clause, my lord, the requirement is that the officer should process the file, my lord, for vigilance clearance, my lord.
Yes.
Yes, ma'am. This is also, my lord.
This is a procedure,
my lord.
procedure to be adopted by the department
Yes, my lord.
for issuance of clear. How you can stop that? How you can be aggrieved? You just think that you just go and ask for the business clearance and it has to be issued to you.
No, I should not, I
It's a
should not seek,
procedure
I should
adopted-
not seek the vigilance clearance, my lord. They have the process, my lord.
Yes, they'll do. They'll do.
They have not done anything, my lord. They
So
have not
how-
done anything.
These are the procedure.
Yes, my lord.
Are you saying that it has not been followed?
Yes, my lord.
But why you are challenging this?
This is not the requirement because this is not the requirement of my recruitment rule, my lord. This not
Requirement
my-
is not that issuance of a clearance, I mean, giving a clearance certificate is something different.
My lord.
Requirement of recruitment is another thing. Sorry.
There has been no amendment to my.
Are you saying that the authority cannot adopt any procedure?
When the executive order passed, my lord, executive
Sorry.
order pass an order, my lord.
Can
It
you
has to be
say
in the
that
name of the governor, my
executive
lord.
doesn't have any power to issue executive order?
It has to be in the name of governor, my lord.
Where? Where it is?
My brother has, my lord, relied on Article
I'm
1,
sorry.
Article 154 and Article 166. my
Read
lord.
it, read it, come back properly. This is a policy and the procedure adopted by the authority.
My lord, I will rely on the judgment, my lord.
Yes.
Yes. Sir. And page 66 again, my lord. Same, my lord. In person modification to order, so 25 February 2020, my lord.
Yes.
This is also I have impugned, my lord.
Same thing.
Same thing, my lord, same thing.
Yes.
Now, my lord, what happened, my lord? Owing to the vacancy, my lord, on 2 February 2017, my lord.
What is it, 2020?
Same thing, my lord. This is the type copy, my lord.
Then
Page 75, my lord. Owing to the vacancy to the post of Deputy Forest Ranger, my lord. The respondent authorities has, my lord, made correspondence to their counterparts, my lord.
Yes.
Seeking NOC and vigilance clearance, my lord.
Yes.
Now, my lord, the type copy is there, my lord. I am at page 83, my lord. I am at serial number 57, my lord.
It's okay.
Yeah.
We are not disputing anything.
No, my lord.
You may be
My
entitled.
lord, what I am saying, my lord,
To be entitled.
there has been so many DPCs, I was never considered, my lord.
It's okay.
Now, my lord, due to my due promotion, my lord, I have submitted a representation to the Deputy Commissioner, my lord, on
Yes.
6/3/2007, page 88, my lord, highlighting every fact, my lord. Now, I say, my lord, initially, my lord, I have been occupation of land measuring 495 square meter, my lord. Now, what happened, my lord? The Deputy Commissioner, my lord, in the year 1998, 24 July 1998,
Forget it now. In view of the instruction that you have not encroached anything,
yes, my lord.
you just submit on the legality. I mean, if you are challenging these requirements,
Yes, my lord.
the procedure adopted
My lord.
by way of an office memorandum. If you are challenging this, you
I
are.
am also, my lord, trying to
whether you are
impress that my conduct is
whether-
also not bad.
Just wait. Whether you are encroached or not, that has been clarified that there is no encroachment.
Yes, my
You
lord.
are entitled for an NOC.
Yes, my lord.
That is different thing.
My lord.
We'll record that in view of this instruction.
My-
Right?
Yes, my lord.
Mr. Addition AG, we'll record your this
Yes, my
instruction.
lord, as per this instruction.
We'd like to hear you
Yes,
on the legality of this procedure,
My lord.
your so-called impugned orders.
Yes, my lord.
You are going is
My lord.
nothing else.
Yes, my lord. So, my lord, by my lord, para 16, my lord, I have challenged, my lord.
Para 16.
Yes, my lord.
Paragraph 16.
Paragraph 16, the relevant portion would be para 30, my lord, or page 30, my lord. Page 30, my lord.
Yes.
1, 2, 3. My lord, 8th line, my lord, from above, my lord. It is discernible, my lord.
Yes.
It is discernible that the respondent authority is being influenced by the impugned order dated 2/4/2020, 2/4/2013, 6/6/2017, 11/5/2018, and 25/2/2020, my lord, have not considered the case of the petitioner for promotion. It is imperative to mention herein that the impugned order dated so and so, having no force of law, it cannot override the recruitment rule framed under Article 309 of the Constitution of India, my lord. Now, my lord, para 17, my lord. Page 31, my lord. Same thing, my lord. As per the, same thing, my lord, as per the aforesaid recruitment, there is
According
no
to the-
provision for want of NOC and vigilance for consideration of promotion, my lord.
Are you saying that only the recruitment role
Yes, my lord.
is to guide for your promotion?
Yes, yes, my lord.
Regulate your promotion?
Yes, my lord.
And certain issues, suppose the requirement of, unless it is provided in the recruitment rule.
Yes,
like
by way of amendment, my lord. Yes,
vigilance certificate
yes, my lord.
and NOC,
My lord.
it cannot, they cannot ask for this.
Yes, my lord. My lord, para 19, I have specifically said, the petitioner will express on the basis of the impugned order dated so and so, which is not having any force of law, my lord. The respondent authorities cannot deny petitioner his due promotion, my lord.
What do you mean by having force of law? Having no force of law?
My lord, this notification circulars, my lord, they have not been issued by the company in the name of governor firstly, my lord. And my lord, they does not have any force of law behind their back, my lord. Because it has to be issued in the name of governor, my lord. Being the executive head, my lord. Now, my lord, also have stated, my lord, it is a matter of fact that notification, circulars, memorandum, etc. has no force of law and it cannot override the recruitment rule framed under Article 309 of Constitution of India, my lord. Now, my lord, I would like to rely some judgment, my lord. First, my lord, 2001 5 SEC. Page 482, my lord.
2001?
2001 5 SSC.
Yes.
482, my lord. Rajendra Singh was State of Punjab.
Hmm.
Para 7, my lord.
Hmm.
May I read, my lord?
Yes.
The settled position of law is that no government order, notification, or circular can be substituted of the statutory rules framed with the authority of law. Following any other course would be disastrous as much as it would deprive the security of tenure, right of equality conferred upon the civil servants under the constitutional scheme. It would be negating the so far accepted service jurisprudence. We are of the firm view that the High Court was not justified in observing that even without the amendment of rules, Class 2 of the service can be treated as Class 1 only by way of notification. Following such a course, in effect, amounts to amending the rules by a government order and ignoring the mandate of Article 309 of Constitution of India. Now, my lord, 2020, my lord, 4 SSC, 346, my lord. This is Dr. Hiralal case, my lord. This pertains to pension matter, my lord. But here, my lord, some
2024 SCC?
346.
346.
Para 18, my lord. 18, my lord. May I read, my lord? Yes, my lord. In our considered view, the circulars dated 22/8/1974 and 31/10/1974 and government resolution number so and so dated 31/7/1980 were merely administrative instruction, executive orders. They were not issued in exercise of power under Article 309 of Constitution and cannot be said to have the force of law, my lord. Now, my lord, 2007, my lord. 2007 6 SSC 704, my lord.
Yes.
This is the case of my lord, Union of India versus Sangram Kesari Nayak, my lord. Para 11 and 12, I would like to read, my lord. 11 and 12, my lord. May I, my lord? Promotion is not a fundamental right. Right to be considered for promotion, however, is a fundamental right. Such a right brings within its purview an effective, purposeful, and meaningful consideration. Suitability or otherwise of the candidate concerned, however, must be left at the hands of the DPC, but the same has to be determined in the terms of rules applicable therefore. Indisputably, the DPC recommended the case of the respondent for promotion. On the day on which it is accepted at the bar, the DPC held its meeting. No vigilance inquiry was pending. No decision was also taken by the employer that a departmental proceeding should be initiated against him. Para 12, my lord. The terms and conditions of an employee working under the central government are governed by the rules framed under the provision appended to Article 309 of Constitution of India or under a statute. The right to be promoted to a next higher post can thus be curtailed only by reason of valid rules. Such a rule again, however, cannot be construed in a manner so as to curtail the right of promotion more than what was contemplated by law.
Please come to, it's over.
Last, my lord.
Yes.
This is my lord KV Janikara Man, my lord.
Janki Raman.
Yeah, Janki Raman, yes, my lord. Here, my lord, there was a criminal case pending against the person, my lord. I don't have any criminal case pending. There is no departmental proceeding pending against me, my lord.
We have dealt it 100 times.
Para 17, my lord. That 1991 for SSC 109. My lord, your lordship knows this case then.
I don't know.
Oh, may I read one? There is no doubt that there is a seeming contradiction between the two conclusions, but read harmoniously and that this is what the full bench has intended. The two conclusions can be reconciled with each other. The conclusion number one.
Paragraph?
Para 17, my lord.
17.
Conclusion number one should be read to mean that the promotion, etc., cannot be withheld merely because some disciplinary or criminal proceedings are pending against the employer.
Still cover. It's
Still
about
cover,
still
obviously,
cover.
Your Honor. When there is a criminal case pending against, well, I don't have any criminal case. I'm relying on this judgment because there is a criminal case pending against that person. I don't have any criminal case pending. No DPC, Your Honor.
Pass.
Over, Your Honor.
Come to page 110.
Oh, my lord.
Your recruitment rule.
Page 110. Yes,
Yes.
Yes, my lord.
Rule, this is schedule 1.
Yes, my lord.
Clause 11.
Clause 11, yes. Yes, my lord.
Read it.
In case of recruitment by promotion, deputation, by way of
Requirements or procedure.
My lord.
NOC, subject to what is said, NOC may not be, I mean, suppose if there is a encroachment.
My lord.
Subject to the final determination by the examination by this court. But rest of the impugned orders is a procedure, are the procedures to be followed while issuing a certificate. That you cannot object to it. It's a procedure to be followed by the authority. While issuing a business certificate.
For promotion, my lord, the CCS conduct rules will follow. For my lord, consideration of promotion, my recruitment rule will follow.
You are saying that
yes, ma'am.
If criminal case is pending,
yes,
what is to be done?
Yes, my lord.
Is there any provision in the rule
no,
that if the criminal case is pending, what is to be done?
That would be guided by my CCS rule, my lord.
Yes.
Yes, my lord.
What CCS rules? What CCS
Civil service, my lord.
What are the assessment? What are to assess?
For that, no notification is required, my lord. For that, notification is required, my lord. For that, no notification.
What
is-
notification?
This impugn
This
notification.
is the procedure.
procedure they can follow, my lord. They
Then
can
your
follow.
business is, good.
My lord,
Are you saying that no business clear evidence is required?
my lord, I say, my lord, they have the procedure, my lord. It doesn't mean that they can pass any impugn order, my lord, requiring that NOC, my lord. They have to process, my lord. As per the impugn orders, my lord, it is the joint director, my lord, they have to follow the procedure, my lord.
Yes.
But they have not done anything, my lord, because of this, my lord, and this notification, my lord. It says, my lord,
Doing nothing or doing anything is different. The procedure adopted by the department for
Yes,
issuance of the business clearance.
Well,
How you can be aggrieved of this?
because of this, my lord,
Suppose-
impugn orders, my lord.
Suppose you are entitled to some certificate,
My lord.
right?
Yes.
From the authority. If authority adopted procedure
Yeah.
that this is go to this table, those things, can you challenge that? What you want
No.
is your business certificate.
But they are
What
not.
procedure they follow?
Because, but they are not
You
guided by
want that
recruitment
once
rules, my lord.
one business clearance is asked for, you have to give it.
But my service
You
conditions
have to
is
be
there.
given.
My service conditions there, my lord, which has been framed under Article 309, my lord. Now that has to be followed. my
Let
lord.
us see. Show us from this rule.
There is
Show us.
there is no requirement, my lord, of this NOC and vigilance clearance.
Therefore, only you have to be a forester, having a 5 years of service, then you will be promoted.
Yes,
That is
ma'am.
what your submission.
Yes, my lord.
Very strange submission. Your submission is rejected. Then
No, my lord. Then I will again, my lord, strengthen my phone, man. My lord, this, my lord, orders, my lord, which are issued, my lord, by the authorities, my lord, that has to have some force of law, my lord. That has to have some source of law, my lord. To amend, my lord, my recruitment rule, they have to take the shelter of Article 309, my lord. Now, without recourse to Article 309, how can they, my lord,
Article
issue
309,
notification?
you read Article 309.
Yes, my lord. Now, they have to amend it, my lord.
Huh?
They have to amend my recruitment rule, my lord.
You read Article 309.
I don't have the constitution. May I?
Yes.
Yes, my lord. So, my, it's, my recruitment rule can be amended by the governor, my lord, of state, my lord. Not by this, my lord, government officials, my lord.
Read it.
Yes, may I, my lord.
Not Article 309, it's proviso to Article 309.
Yes, sir, proviso, yes. Sorry.
Read it, proviso.
Proviso, yes. my lord.
Provided that
Provided that it shall be competent for the president or such person as may be direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as may be directed in the case to make rules regulating the recruitment and conditions of persons appointed in that behalf is made by or under an act. It should have a statute, no? Or of the appropriate legislature under this article, and any rules so made shall have effect subject to the provision of any such act. This is not an act, my lord. This is not a statute, my lord. It does not have any force of law. That is why I'm submitting it. It does not have any force of law, my lord. It has not been issued in the name of governor, firstly, my lord. It is not an act nor statute, my lord.
it is not required, sir. Page
My lord, my
64,
recruitment rule is framed by
60.
governor in the name and by the secretary of my department. My lord. This vigilance department does not have anything to do with my department. My lord.
The following procedure shall be adopted with immediate effect. This is the procedure adopted
My lord.
for issuance of a vigilance clearance.
My lord.
How you can stop that?
My lord, how can a principal, my lord, this vigilance, my lord, Department of Vigilance will govern my recruitment rule, my lord. I am being governed by my recruitment rule framed by my secretary in the name of governor, my lord. Now this vigilance department, who is a my lord, stranger department to me, my lord, how can they amend my recruitment rule, my lord?
Sir, this court has some little confidence on you.
My lord. But that is the submission, my lord.
No, no, no. You make a submission. I'm
No.
hearing you.
My lord.
But I have some confidence on you.
My lord. Well, that is why I'm saying, my
Try
lord,
to
this-
live, try to live up to that.
I have fired every gun, every
You
bullet.
just
I have.
cannot fire every gun like this, every bullet like this. Whatever comes to you.
My lord.
Try to get a better bullet and fire in the right place
No, my lord.
and the
this-
right time.
My lord, this matter may be disposable. Well, for 36 years, my lord. Now I'm going to retire, my lord.
That is precisely why I'm trying to let you know.
My lord, your honor, your lordship has seen that there has been some instruction, my lord, that I have not occupied any government land, my lord. Now, despite that, my lord, 36 years now, I'm going to retire, and then, my lord, still I have not been considered, my lord.
That is something different.
My lord.
Don't jump to that grievance.
Yes, my lord.
First, you stick to first complete your what you are on.
I'm complete, my lord.
You are challenging the impute orders
Which
passed
does
by
not-
the authorities.
My lord, yes. That's why, my lord, this vigilance department, my lord, they are stranger to my department, my lord.
Hmm.
They are not from my department, my lord. They are not amending my recruitment rule, my lord. My recruitment rule has been framed by my secretary in the name of governor, my lord. I have my department, my lord. I
Sir,
follow my recruitment rule, my lord.
With that is the reason I'm trying to let you know.
Yes, my lord.
I have some confidence on you. Don't argue. like
I'm done with my submission. my lord. This matter may be disposed of, my lord.
My lord, I believe there will be no requirement for my submission. My lord, totally on a misconception that recruitment rule will provide for everything. My lord, my learned brother has forgotten where will the reservation policy go, where will be sports quota go, where will be the handicap quota go, whether it will be provided in the recruitment rule. Oh, he himself has candidly admitted that if there is a criminal case pending, that this will be required. That if there is no criminal case, then we will there should be this vigilance clearance. He himself is admitting, but his only contention is that there is no amendment in the recruitment rule. The recruitment rule has not been. There is nothing provided in the recruitment rule. Well, for that,
but one thing, NOC, so far as NOC is concerned,
my lord,
unless
this is to answer to my learned friends. This is the manual which has been issued by the vigilance. This, my lord, will see it is issued by the chief secretary, come CBO. Last,
which one?
Second page, my lord.
Yes.
Notification of 5th July 2022.
Yes.
In the issued by the chief secretary, come CBO, my lord.
Yes.
Now, in the last para, if my lord will see, now therefore the governor of Arunachal Pradesh is pleased to notify the Arunachal Pradesh Vigilance Manual 2022.
Yes.
This itself shows, my lord. And all these notifications, whatever orders, whatever my learned friend is harping on, that it is not issued in the name of the governor, that itself clarifies, my lord. There cannot be any quarrel, my lord, on that. My lord, therefore, my lord, only to the expect whether by way of executive instruction 2022-12 NK Nosad Rahman
2022
12 SCC
12 SCC
page 1.
Para
para, my lord, will 28, 29, and 30. I'll just read. It's small paras, my lord.
Yes.
Norms applicable to the recruitment and condition of service of officers belonging to the civil services can be stipulated in 1. A law enacted by the competent legislature, rules made under the proviso to the Article 309 of the Constitution, and 3. Executive instructions issued under Article 73 of the Constitution in the case of civil services under the Union, and Article 126 in the case of the civil service under the states, madam. This, where the rules, recruitment rules under 309 is silent, under 162 executive instructions can fill up the gap, madam. That for that only, madam. And further, where there is a conflict between the executive instructions and the rules framed under Article 309, the rules must prevail. In the event of a conflict between the rules and framed under Article 309 and a law made by the appropriate legislature, the law prevails. Where the rules are skeletal in a situation when there is a gap in the rules, executive instructions can supplement what is stated in the rules. 22, volume 12.
Yes.
That's okay. That suffice, my lord. Executive instructions can supplement. That is, therefore, I was telling that it is totally on a misconception of
So
law.
all the impugn orders are under this manual,
Yes, my lord.
including a requirement of NOC.
Yes, my lord.
Where it is?
Yes. All has incorporating all the appendix itself, my lord. In the appendix, all the previous orders and notifications, my lord.
Appendix B, Roman 5.
Starts from Roman 3 also, earlier.
No, this.
Yes, my lord. This is CBC guidelines, no? Roman 5 is.
Executive orders and administrative instructions, they are different.
Comes under delegated.
19. This is a compilation of earlier.
No, that's what I'm asking. This requirement of
Yes, my lord. Yes.
NOC.
Yes,
Where
if
it
my lord comes to chapter 5, vigilance clearance, at page 11 in the bottom.
11.
Yes, in the bottom, chapter 5. 5.5, is the procedure for issuance, and if Roman 5, we'll see in the next page, at page 12. Status of government land encroachment shall be submitted by the concerned deputy commissioner as per the decision taken in the cabinet. Issue. So. This is there, Mal.
Yes. Nothing. These orders are in terms of 162. May not be, not necessarily 154, 166. It's 162. Orders.
I am bound by certain.
Now,
This notification, this
Now,
this executive order, it's a manual of 2022, Malad. As per my knowledge, Malad, the last notification is 2020, Malad.
Now this court will try to lay down the law.
This notification, Malad, this impugn orders, Malad. The last impugn order, Malad.
This 2024.
It's okay. That's all.
Malad, in my case,
Yes.
that chapter 5, that page 12, it says,
Your case will be dealt separately.
no, yes, no, that's that particular thing.
I'll record your submission, but then I'll not consider because there's no pleading
No,
to the trigger in that case.
no,
So far as
no,
160.
that's why.
That
on
I'll
the-
not
I'm
consider.
not asked onto that aspect.
Huh.
What I'm saying is, since the AAG has made a submission that in spite of cancelling the temporary land allotment, I am still the encroacher.
Yes.
But here it says, in case of encroachment of any type on the plot or the premises made by government employee, vigilance clearance shall not be given by vigilance department unless the concerned DC gives a clear report of being removed completely. So therefore, my lord, my respectful prayer in this is kindly request the AAG to get an instruction whether I am an encroacher or not. That much.
No, I'll dispose it of. We'll consider everything.
That's fine. That's my lord's domain. That's my lord's
Because
domain.
this court has heard you to dispose of the matter, right?
That's fine, my lord. That I'm not quarreling also.
Well,
and then why should I go into the domain of my?
What do you say? Can you take instruction that whether
There
he is
is
an
no
encroacher or not?
There is no pleading by himself that.
No,
yes,
no. He said whether you can obtain
And he has also made submission beyond.
you
the
can obtain
affidavit,
that whether he is an encroacher or not.
My lord, that is already there in the documents itself, page 27, what I have shown, my lord.
According to
Eh,
them, you are an encroacher.
No.
After being evicted again, refenced.
That is
the-
an old version, my lord. Now we are, that was the action in 2023. Now we are in 24.
You have filed an additional affidavit.
Yes.
Refenced, after being evicted,
No,
refenced.
That cannot be. Otherwise, my lord, it is a settled position of law. Relief can always be mounted. Is subject to the condition that action of any citizen is not perverse to the national interest. But for this tribal being, punishing any individual, any citizen may not be appropriate. Only that aspect.
Yes. Heard Mr. T.T. Tara, learned counsel for the petition, and also heard Mr. N. Ratan, learned additional advocate general for the state, for respondents. Hearing concluded, judgment to follow. Same. Next page, the next case, Atempotina, and Mr. B. P. Chairman, counsel for the petitioner. Same, huh? And return for additional advocate general for the state. And additional advocate for the state. Hearing concluded, judgment to follow.
Obligation. May I make an unusual request, Lord? Item 32, Lord. I have some difficulty and the other side is also not there.
You ask someone to be there, we'll see.
It is in a hearing list, Lord. It will not be.
Let us take the pain together.
315 already, Lord.
Huh?
315 already.
Doesn't matter.
Item number 15.
May I, Your Lordship? And Lordship, this matter may be listed on this 22/4, Your Lordship.
Why?
Actually, here, additional senior government advocate got GAT appearing in this matter. He instructed me to adjourn this matter on.
You want to file affidavit in reply? No.
Yes, madam.
Mr. So learned counsel for the petitioner.
After
Fresh court is granted 3 weeks time to file affidavit in reply. MSP Pango learned state council present. List up to 3 weeks.
Oblige, Your Lordship.
Yes. We will take up to something. We'll finish this listed matter.
15, 17, 16 to 19.
My lord, we haven't received the reply from respondent number 2 and 3.
Who is appearing for respondent 2 and 3?
Here, Your Lordship, item numbers,
My
Heard
lord,
Mr. So-and-so, learned counsel for the petitioner. You are for
I'm for the
MSP
state,
Pango, learned state counsel for respondent, state respondents.
yes, Your Lordship, state respondent.
You have not filed affidavit.
Here, we have filed, Your Lordship, on item number 16.
2 and 3, who is 2 and 3?
My lord, Department of Land Management and.
Oh, yes,
Well, Mr.
land management to file counter affidavit.
Mr. So-and-so, the company, learned state counsel appearing for respondent 2 and 3 is granted 3 weeks time to file affidavit.
I have a difficulty to appear in this case because.
You cannot appear.
Yes, writ petition. Counsel.
In that case,
Yes, I'll have instruction from the department. So that the department can engage.
you make some arrangement, talk to the department.
Yes, yes.
Then in that case, you last line, Mr. D. Kamduk. Mr. D. Kamduk, learned standing counsel, land management department, express his difficulty in appearing this matter, for which he, for which he pressed for listing the matter after 3 weeks.
Yes.
List after 3 weeks.
Deeply obliged.
My Your Lordship,
Yes.
I'll be representing the petitioner and I'm filing.
You are for respondent number?
No, I'm for petitioner.
Petitioner.
Yes, Your Lordship.
Okay, MS.
Etalom.
A. Thalam, learned counsel by, you file in the registry, not before here.
Ah, okay, yeah.
Sought for a time to file her power on behalf of the petitioner in this present matter. Mr.
For all respondents.
For all,
My lord.
Mr. M. Kato, learned DSJ,
My lord, I'm sorry, 1, 2,
appearing
5.
for all the respondents.
1, 2, 5, not
Who
6.
is 6?
6 is private respondent, my lord. Subsequently, the work.
From
has
1
never-
to 5 present. List this matter after 2 weeks.
My Lord, I may be allowed to file a rejoinder.
2 weeks. The learned counsel MS A. Thalam, learned counsel A. Thalam is permitted to file a rejoinder to the additional affidavit of filed by the respondents after filing our power. Less after 3 weeks. 3 weeks.
Developed.
25. This is the Gaubura matter, head Gaubura. List this matter before any other bench without me.
May I please, Lordship? Lordship, I'm for private respondent number 3 and 4.
Yes.
I may be kindly grant 1 week time to file affidavit in opposition.
What about the state?
They have filed.
Mr. Dick.
They have filed, Lordship.
They
And
filed.
in fact, Lordship, the private respondent, they have been seeking time for filing affidavit for so many occasions.
1 week only. 1 week.
1 week.
1 week.
It's fair enough. Mr. D. Mr. D. Kamduk, learned counsel for the petitioner. Mr. X. Gyati, learned counsel appearing on behalf of the private respondents. Press
3 and
release
4.
granted 1 week, granted a week's time to file affidavit in opposition. Mr. I. Ram Swens,
As a license, Lordship, because
learned additional senior government appears is present.
in the event of failure to file the affidavit, Lordship.
You'll file. Have some faith on your
Lordship,
colleague.
he has been seeking time for filing affidavit.
1
for
week.
so many- Yes,
1 week
1 week
only.
is nothing, of course, but for several times he has been
In
taking
the,
time for this filing affidavit.
in the event the respondent number 2 and 3 and 4 fails to file affidavit within 1 week, the matter shall be taken up for disposal without the affidavit of the private respondents.
Much obliged.
So that you are ensured to file.
Item 27.
My lord, I like to mention for item number 27, 484, 2022, Dachabagan versus.
Yes.
Sir, my lord, it may be listed after 2 weeks. The main counsel is
On
out
the
of the
prayer of
present.
learned counsel for the petitioner, list this matter after 4 weeks. 2 weeks.
Yes, sir.
2 weeks. MSP Pangu learned so and so is present.
Item number 28.
My lordship, we have received instructions. We'll be filing our affidavit. So no problem.
Heard Mr. so and so learned counsel for the petitioner. MSK Wang Malan State Council. Praise for it is granted 2 weeks times to file affidavit of appointment. This after 2 weeks. 3 weeks, huh?
Item 29.
My lordship, some more time may be given, my lordship.
Heard so and so, huh? B type with the learned counsel petitioner. Same order, 3 weeks, huh? K Wang Mo. Praise for it is granted 3 weeks time to file.
Item number 30.
My lordship, in this also we have received instructions. We'll be filing.
Heard Mr. so and so learned counsel, Mr. MS, same order, 3 weeks.
All right.
Item number 31.
I'm sorry, Lordship. Lordship, there is an interim order.
Interim order for silence and continue. Yes.
In this, we need 3 weeks time, my lordship. File affidavit.
MS TY Bhutia Learned Counsel for the petitioner, K Wang Mo, State Council. Spread will granted in 3 weeks time. To file affidavit. List up to 2. Yes. List.
Item number 14. Item number 45.
Yes.
May I please, my lord? My lord, this pertains to tender matter, my lord, in
Yes.
Upper Sumatra district, my lord.
Hmm.
In AD department, my lord.
Hmm.
My lord, may I kindly turn to page 25, my lord?
25.
Yes, my lord.
Hmm.
25 is the NIT, my lord.
Hmm.
My lord will find, my lord, the estimated cost is 9183.53, my lord.
Hmm.
Supply procurement of materials under Minrega
Yes.
for the year 2020. Now, my lord, here, in all together, my lord, 7 firms participated, my lord. 7 firms. Now, out of the 7, my lord, in technical bit, my lord, 2 were rejected, my lord.
Including you?
No, my lord.
Okay.
My lord, can you turn to page 48 now?
48.
48.
Yes.
Now, for that, my lord, a committee was set up, my lord, by the DC cum DPDO, my lord.
Financial bid.
Yes, my lord.
For 5 firms. Your name? Your name?
I am at serial number 1, my lord, the last column, my lord. MS Simon Enterprise.
Simon or Simon?
Si-
Simon.
Simon Enterprise. my lord.
Okay.
Now, if you turn to the earlier page, my lord, here, my lord, down below, my lord, you can see the NIT amount is been given in the second column, sorry, third column, and amount less than 10%. 1,652,654.68. And my bid was 1,655,265.68, which is below 10%. Now, therefore, my lord, after evaluating out of the 7, 2 were disqualified in the technical bid, in the price bid, 5 qualified, my lord. Therefore, my lord, down below, my lord, basing on the rate quoted by all the participating firms, the board recommended the following firms, L1, L2, and LT respectively. The priority has been given basing on precedence and experience of the firm.
Yes.
Now, down will serial number 1, MS Simon Enterprise L1, MS TG Enterprise L2, MS Bugsy Enterprise L3.
Yes.
These 3 firms were recommended, my lord. Now, as per the norms, my lord, the technical evaluation board would evaluate the bids and then they would send it to the directorate office at Itanagar, my lord. And the directorate will give the letter of intent and the work orders will be issued by the PD, the project director of the concerned district, my lord.
Yes.
Page 47 is the letter by which this the evaluation committee has sent this.
47.
47 is the letter, my lord. 21 February 2024, my lord.
Yes.
Now, well, I was contented, my lord, since I being the L1, the tender would be awarded to me, my lord. My lord, can you turn to page 53. White letter dated 27 February 2024. The joint director, on behalf of the director, rural development, has written a letter to the project director, DRDA Daporijo, Upper Subansiri district, calling upon the tender papers of all the firms who had participated in. Now here, even he has called upon the bids, technical and the financial, of those firms who were even rejected in the technical bid.
Yes.
This is the impugn letter challenge.
Commission.
My lord. Pardon, my lord.
Okay.
RT was not recommended, my lord.
Okay.
RT was not even recommended, my lord.
Yes, yes.
Why this letter, my lord? The Director of Rural Development has issued a letter of intent to the RT Enterprise, my lord.
Yes.
Therefore, I'm challenging this order, my lord, it being arbitrary, my lord, and nullified. And he has not assigned as to why my firm being recommended by the board, evaluation, or the tender evaluation board, and I being the L1, why I was not offered the letter of intent.
Yes. Board has recommended forms.
Yes, Lord.
And the director has issued a letter LOI to the form which has not been recommended on the form.
Now, what happened, my lord? Yes, my lord. They have they bid of 3 firms.
Yes.
But we have to committee, my lord.
Under what authority you have decided what is the reason?
Page 40, my lord, page 40A.
40.
40.
My lord, may kindly turn to page 40, my lord.
So 40A is the type copy, my lord.
40, my lord. Now, this is the terms and conditions of the tender, my lord. My lord, may kindly see serial number 14. Awarding of contract works. May I read, my lord?
Board's considered DC company.
The tender shall be evaluated by the board constituted by the DC at the district level and recommend at least 3 firms, L1, L2, and L3 to competent authority. Acceptance along all relevant documents. The joint director, RE, shall furnish scrutiny, further scrutiny, the tender documents recommended by project director.
Who is the accepting authority?
Director, my lord.
Director.
Yes, ma'am.
The LOI will be issued to L1 to the L1 firm if the tender documents recommended by the project are up to the satisfaction of accepting authority. The project director will issue supply orders to the L1 firm in the basis of LOI issued to the accepting authority. Now the private respondent here in my lord, his firm was not even recommended, my lord.
My lord. And then, my lord, after my lord, securing the bids of all the bidders, my lord, we have further, my lord, scrutiny in the directorate level, Itanagar, my lord.
Who has done it?
Constituted by the, my lord, in the directorate level, my lord, by the joint director and APORE, 3 board members, my lord. On the extreme right side, my lord, may see the scrutiny, financial scrutiny. On the extreme right side of your lordship, my lord. Yes, my lord. On the top, yes, my lord. This is the financial scrutiny, my lord.
Technical
and financial, my lord. Both are there, my lord.
Okay.
Now, my lord, the differences in their financial bid is, my lord, only 16,553 rupees, my lord. $16,000 only, my lord, difference, my lord. 16,553 rupees, my lord.
My lord, in the tender document, there are certain terms and conditions.
It has been further scrutiny, the tender documents recommended by project director.
Yes, therefore, my lord,
According to them, it has been scrutinized.
Yes, my lord. I'm coming to that, my lord. But my lord, may kindly come to 15, my lord. 15.
15.
No, here, page 40, serial number 15. Down below, my lord, 9. Acceptance of tender at justified rate with allowable variation as per PWD manual 20.4.3.2 shall be strictly followed. Now, as per the evaluation, my lord, the bid of the private respondent is above 10%, my lord, which is not permissible, my lord. But my bid is within 10%, my lord. Therefore, I was recommended, my lord, as L1, my lord, by the tender evaluation board, my lord. If my lord come to
It's okay. We'll examine.
It's very clear, my
Don't
lord.
proceed.
Not to finalize, my lord.
Don't proceed. You have issued the LOI.
Yes, my lord.
That may be straight, my lord.
This order, the further scrutiny has not been challenged, my lord. Further scrutiny, my lord.
We are not aware of it, my lord. We are only aware of.
We'll see. You bring the record. We'll see. All right. Heard Mr. Opada, learned counsel for the petition. Also heard Mr. DP Chair, learned standing counsel for all the respondents.
My lord, only the state respondents was.
Respondent number 1, 2, and 3.
1, 2, 3, yes,
Challenge made in this petition is the letter of intent number, page 99, huh? So and so, it is 6/03/2024. Issued by the Director, Rural Development Department. Whereby
My lord,
respondent number 4.
the accepting authority has not been made as a party, my lord. My lord, state has not been made as a party, my lord. Secretary RD has not been made as a party, my lord.
Just wait. Whereby the respondent number 4. Is it respondent number 4?
Respondent number 4 is the.
Why you are saying director RD?
Yes, my lord.
Should be secretary?
It
Yes,
may be
my
a-
lord.
my lord, I'm extremely sorry, my lord. It may be a typographical mistake, my lord.
Let them file a reference, my lord.
Correct.
My lord.
Whereby the respondent number 4 has been whereby the letter of intent for procurement of materials under MGN Rega 2020-24 pertaining to CD block Talia Upper Subansiri district has been issued. Pursuant to the NIT, which state?
My lord.
NIT, pursuant to the NIT dated
27/1/24.
27/01/2024. Next paragraph. It is the contention of the petitioner that the duly constituted evaluation, tender evaluation committee has recommended the name of the the form of the petitioner along with 2 others. The respondent, private respondent number 4 has not been, name of the form of the private respondent has not been recommended. Mr. Opada, consider the petition referring to the terms and condition.
My lord.
Or is it the terms and conditions of the NIT? Submits that the acceptance of tender at justified rate with allowable variance as per CPW manual shall be strictly followed, comma. In the present case, the rate quoted by the petitioner is within 10% variation.
Permissible
variation. However, the rate quoted by the private respondent is above the permissible variation. Next paragraph. Mr. B. Pitcher, Standing Counsel, by placing the written instruction,
yes,
submits that the bits of all the bidders have been re-scrutinized. No, has been have been scrutinized at the level of directorate.
Yes, my lord.
Thereafter, on having been found to be more responsive, the form of the respondent number 4, the LOI has been issued. Issue notice returnable by 3 weeks. 4 weeks.
My lord.
Returnable by 4 weeks.
And what I say, my lord, not to finalize the work, if not finalized, because this impugn LOI has been issued on 6 March, my lord. Now is the 2nd April, my lord.
Issue notice returnable by 4 weeks, within 4 weeks, huh?
3 weeks, my lord.
Since Mr. So-and-so, 3 weeks. Be feature, learned counsel for the respondent and to appearance on behalf of respondent number 1, 2, and 3. No formal decision. Our extra copies be furnished to the learned counsel during the course of the day. The petitioner to take steps for service of notice upon respondent number 4. Cover. In the interim, considering that the petitioner has been recommended along with 2 other firms being L1 by the Tender Evaluation Committee. On the submission and considering that the respondent number 4 has quoted the rate which is beyond the permissible variation, comma, in the interim, comma, the tender process is hereby suspended, particularly the impugned LOI is not to be given effect to.
Not to finalize.
Irreturnable that.
Not to finalize. Because this is of 3rd April, my lord. 6 March, my lord. Today is 2nd April, my lord. 1 month has already gone.
It's a prime view of this court. Okay, we'll see.
My lord, this,
If I can correct it by hand.
It's not permissible.
not
You
permission.
file an amended course that.
My lord, obliged, my lord.
Obliged.
Yes, sir.
Well, it's challenging the impugn action.
Yes.
Of the complaint lodged by Chairman State Vigilance Commission under National Food Security Act. And my lord is aware of the proposition that a person not aggrieved by the order cannot be appellant. In any case, my lord, that Madam Ate was handling this matter. And
So-
I have been requested that he is not ready.
What is there? You ready? Do you have the file?
I have the file, but
Do you have the brief?
I have not gone through it.
Read and submit what's there.
Well, accommodate me. I have some personal difficulty also. Election period.
Only prayer of learned counsel for the parties.
After
List
reopening.
List this matter after
Reopening.
3 weeks.
Yes. Grateful.
Wait, Vijay.
Yes.
One of petitioner is challenging the punishment imposed on the petitioner after departmental proceedings of withholding of 2 service improvement with cumulative effect and the consequent dismissal of the appeal in the review matter. The grounds on which the impugn actions are being challenged are in a nutshell, my lord. The petitioner was not allowed to cross-examine any of the witnesses. The other persons against whose the departmental proceedings were proceeded, there were 3 other persons. The statements were also recorded. They were taken into consideration while coming to the finding of guilt against me. I was never given any opportunity to cross-examine them.
That's the only ground.
That's the only. Page 21 is the memorandum of charge. I'll just point out what had happened. On 5.3.
It will take time.
My lord,
Will you be able to complete?
this will take some time. Inquiry matter.
Yes, that's why.
Otherwise, my lord, please.
Next week, let us
Next
see
week.
next week.
Another matter.
On the prayer of the Lord Council for the Father, list this matter after a week.
After a week.
We'll see.
My lord, there's another matter, 35.
35.
Can this be taken up tomorrow, my lord? This will not take much time.
Okay.
Yeah. It's a simple matter, my lord. The department has continues the use the term compounder. The compounder is not recognized by the pharmacy council.
Okay.
Earlier we only used to know
It's a
compounder.
pay penalty,
Yes, pay penalty.
but then ultimately we'll have to send it to the before the.
Yes, but along with some observations, because apparently compounder and pharmacists are the same thing.
Next week.
Next
Let
week.
us see next week.
Next week.
Hmm.
Monday, man.
Item 35. Tuesday.
Tuesday.
On the prayer of Mr. Deepak London Council, list this matter on R90904 2020.
Obliged.
Item number 34.
Yes. My lord, I need some more time for filing affidavit.
It's been listed for hearing.
Yes, but without affidavit, it won't be possible.
Any objection? No.
Senior counsel is also not present.
You are also seeking time. Mr. MS T.Y. Butchi, Learned Counsel for the petition, Learned Counsel for the petitioners. Petitioner, Mr. T. Kamduk, Learned Standing Counsel for Land Management Department. Praise for his grant. Left him.
Much obliged.
Yes, I'm. Madam, my lord,
Take time.
my lord,
Can you complete it today?
my lord. But I will say, my lord, matter can be picked after vacation, my lord, that will paucity of time, my lord. After vacation, my lord. That
Okay. That's a matter.
no, my
You
lord,
are
this is
challenging the other proceedings.
other no, my lord, this is pertaining to other disciplinary proceeding, my lord.
Huh?
Other disciplinary proceeding, my
Oh,
lord.
that was encroachment and this is
This is, my lord,
non joining,
non-compliance.
non compliance with transfer.
My lord.
Anyway. On the prayer of Mr. El Preme, Learned Counsel to the petitioner. This matter after 3 weeks. 3 weeks. Mr. I. So and so. I read up Learned Edison Senior Governor present.
हम भी सिर्फ आलू करके फिटनेस नहीं बना है
नहीं हो रहा है या इसको ऑफ करने का जगह क्या हो गया वीडियो को लाइव को वो गायब ही हो गया हम ये देखो ना ये जो ना ये हम मिनिमाइज करके ये कर रहा था तो ऐसा आ गया वो तो चेक कर रहा था अभी यहाँ से कहाँ दे इधर इधर नीचे रखा लेकिन वीडियो तो चल रहा था और जूम भी देगा ना तो हम ये को नहीं किया उसको निकाल के ना निकाल के तो वीडियो